Good morning, everyone, and you're welcome to the two-day sensitization event on the 2023 ROPC rules for legal practitioners. We thank you all for coming, and we can see that we thank all our branch chairmen, for joining us for this program. And this event is for 2 days, and we thank God that you all arrived here safely. To kick the program running, we commence the program with the national anthem. Please, can we rise for the national anthem? I call on Ms. Oti Ida, the head of programs, Nigerian Bar Association, for the NBA prayer.
Good morning, distinguished gentlemen. Almighty God, our Creator, we pray you to be with us all, to be with us in all our deliberations, and to direct our endeavors, so that we shall continue in all humility to glorify their name and do that which is right and just for our profession, its members, our fellow men, and our country. Amen.
Gentlemen of the bar, we recognize the presence of the NBA President, Mazi Alfamosigwe, SAN. Mr. President, you're welcome. In our midst, we also welcome the General Secretary of the Association, Dr. Ojibara. You're welcome. Also in our midst, we have the presence of Mr. Yemi Akonbe, former Chairman, Lagos Branch. Mr. Yemi, you're welcome. We call on the NBA President for his opening remarks.
Let me first of all welcome our distinguished colleagues who traveled from different parts of Nigeria to be here for this two-day sensitization program on the rules of professional conduct. Many of us had to endure the hardship of road travel from Maiduguri, from Jalingo, and many other parts because of either absence of flights or for flight cancellations. Some had to endure long wait at the airport, not being sure whether they would be able to make this trip. Despite the security challenges in many parts of the country, our colleagues are here today. No doubt born out of a commitment to advance the profession and ensure that our members are held up to the highest standards of ethical standards in the legal profession. And so I think it will be out of place for me not to appreciate the sacrifices you all have made to be here today. Many persons may wonder, why would a profession like ours, which is governed or whose practice is built on adherence to the rules of professional conduct, be holding a sensitization workshop for its members? Ordinarily, it is a taking that as part of our professional training, we have these rules inculcated in us from our days in the law school, and then it makes me wonder, why wouldn't these rules of the profession be taught in the university? Probably that will be the outcome of this conversation, or that will be a conversation for another day. Many of us, I'm not proud to admit, are not aware that the rules of professional conduct that came into effect on February 1, 2024, or the RPC 2023, has made far-reaching changes to the way we know and practice law. A risk assessment of the legal profession carried out last year showed that many of our members are not aware of their responsibilities and a need to commit to anti-money laundering and terrorism financing requirements. Many of our members still live under the belief that being lawyers, we don't have any need to ask questions. We don't have to ask about questions about who we represent as clients, and that as long as we are paid money, we don't have to question the source of the funds used to pay us. The world has changed. The financing of terrorism and the way that money is laundered across national boundaries and international boundaries have made it imperative that we as members of the legal profession must appreciate our role as gatekeepers, must appreciate the imperativeness of playing an important role to ensure that transactions coming out of Nigeria are not called to question. That as members of the legal profession, we are expected to be like Caesar's wife, that we must be above board. And so, that is why we're having this sensitization workshop, because there is need for us to drill down. Some people say that the lawyers cannot be any different from the society they live in. It may well be that our society has become very permissive, excusing many things, but that is not an excuse for a member of the legal profession to say, after all, every other person does it. We are members of a noble profession, and nobility means that we are not like the ordinary man in the street, that much has been given to us and much is expected of us. And in discharge of our duties to our clients, we must, like the bankers, do what they call due diligence. Know your client. Find out who your client is. Find out what business your client does. Find out how your client earns the money. And so, for example, you're representing client A, and you have charged him so much. And from the nature of his business, he can't pay so much, but he pays you 100%. And tomorrow, money comes from ABC Limited. Tomorrow, money comes from Afamo Sigwe. It comes from Ochai. And no explanation is given to show why these unconnected individuals are making payment for him. Or someday you are asked to receive money in your client's account. And maybe you say, don't worry, we'll pay you. We are going to pay in 10 million into your account. And then 1 billion naira comes. So, oh, we made a mistake. We are very sorry. When they were imputing it to do the transfer, they put 1 billion instead of 10 million. Please transfer 500 million to this place. Transfer it. The point we are making, that this sensitization workshop is very important because the legal profession does not seem to be aware of what it should do. We have acquired the status of a self-regulating body, and that means we must regulate ourselves. Why the NBA insists that we cannot be compelled to obtain SCUML certificate, SCUML, from EFCC or NFIU, that we cannot report to an administrative body. We are not saying that we cannot comply with anti-money laundering requirements. We are simply saying, because of the independence of the bar and lawyer-client privilege, our reports cannot go to an administrative body outside the legal profession. And that is why in the RSPC 2023, the NBA Anti-Money Laundering Committee has been set up, to which lawyers are to file certain reports. It is now for that committee to review these reports as to whether to forward them to law enforcement agencies. So I welcome all of us here, and I believe that when we leave here at the end of these 2-day sensitization workshop, we'll leave here with a better commitment, not only to adhere to the highest standards of professional conduct, but also to deploy our knowledge to make for a better society, where transactions coming out of Nigeria will not be viewed with suspicion, where lawyers will not be seen as aiders or abettors or participants in money laundering. I welcome all of us. There are an array of professionals, mostly colleagues, who will do justice to some of the topics lined up for discussion, and also to thank our partners who have also spent time and money and logistics to ensure that we hold this workshop. We can all make a better society and build a better society where people are treated with respect, where for coming out of Nigeria, a person or a transaction is not viewed with suspicion. And I hope that this aim will not only be achieved here, but will drill down when we go back to our various branches. And once more, I welcome all of us to a fruitful deliberations and pray that God will see us through, and that when we go, God will go with us. At some point in the course of the proceedings, I would have to excuse myself, quietly though, because we have a meeting at the NJC by 11. But I would come back at some point if that meeting finishes in time, because our people are here and I should be here with them. Thank you so very much. You're all welcome.
Another round of applause for the bar president. We recognize in our midst Dr. Ernest Ojukwu, SAN. You're welcome, sir. We also recognize Mr. Peter Omenka, representing the head of programs, ROLAC. You're welcome, sir. We recognize Mr. Zibia Bless Kantugi, the Assistant Secretary, LPDC. You're welcome, sir. Gentlemen of the bar, we welcome the representative of the head of programs, Mr. Peter Omenka, for their opening remarks. Thank you.
The President of the Nigerian Bar Association, Afamo Sigwe, SAN, all other protocols duly observed as laid out by our able President. As a member of the bar, I can only submit myself to that protocol. My name is Peter Omenka. I work with the Rule of Law and Anti-Corruption Program. It's a program that is funded by the European Union and being implemented in Nigeria by the International Institute for Democracy and Electoral Assistance. With us today is supposed to be the head of program, Rule of Law and Anti-Corruption Program, for short, ROLAC. But he has a meeting at the EU headquarters, and that meeting took a bit longer than expected. He went to that meeting with the component manager, anti-corruption component of ROLAC, who is the one leading on this activity. Both of them are unavoidably absent, and Mr. Danladi has asked me to read his goodwill message to the members of this noble profession. So you are all welcome to this two-day sensitization event on the 2023 Rules of Professional Conduct for Legal Practitioners. The International Institute for Democracy and Electoral Assistance is also known as International IDEA, and it is recognized as an intergovernmental organization, not international organization, intergovernmental organization. It has presence in 35 countries, and it is dedicated to the promotion and support of sustainable democracy worldwide. The approach of using the shared comparative knowledge from different aspects of democracy for the exchange of ideas and experience in democracy provided the platform to assist in democratic reforms and influences policies. The 6 focused work streams as outlined are electoral processes, constitution building, democracy assessment, and political participation, climatic change, digitalization, as well as issues on gender equality and inclusion and money in politics are the enabling routes to boost its mandate. The implementation of activities that encourage increased transparency and accountability within a democratic system brings about strategic engagements with the legal industry, collaborative advocacy, human capital empowerment, and fostering synergy through intergovernmental agency mechanisms. The MBA seeks the support of international IDEA, and we are happy to collaborate with the MBA. And that is to promote the peer-to-peer knowledge sharing within the legal professional industry, contributing to international IDEA's objective of increased transparency and accountability of anti-corruption systems and reforms in Nigeria. The problem statement here, what is the problem? The importance of seeking to increase transparency and accountability of anti-corruption systems and reforms cannot be overemphasized, as it is regarded as fundamental to sustaining a democratic system of government. The democratic system of governance comprises a network of interdependent actors, and the performance of each actor, like the MBA, is affected by the performance of others. Within the system, the legal practitioners are recognized to generally work to support progressive ideals, whereby lawyers are expected to be sensitive and create a process to which democracy can flourish. It is relatively fair to acknowledge the unique role that lawyers play in the protection of rule of law within a limited sphere. The legal profession is often regarded as a catalyst for progressive reforms within the legal and societal frameworks of a nation. Legal professionals serve as the architects of the legal system, playing a pivotal role in refining and sustaining the democratic structures of governance. However, issues such as misrepresentation of facts, fraud, exploitation of legal loopholes, deceit, and intimidation have marred the integrity of the profession. These unethical practices pose a significant threat to the legal system and must be addressed before they undermine its foundation. In Nigeria, instances of professional misconduct frequently go unchallenged, suggesting a more widespread prevalence of such behavior. Over the years, there has been an increasing societal focus on the ethical conduct of legal professionals, emphasizing the protection of individuals, clients, the courts, fellow practitioners, and the legal profession itself. This growing concern underscores the importance of upholding ethical standards in law. In response to this, the Honorable Attorney General of the Federation and Chairman of the General Council of the Bar undertook a review of the Rules of Professional Conduct 2007, aiming to address global malpractice concerns and to ensure that the conduct of legal professionals reflects the highest ethical standards. Every society influences its ethical, disciplinary culture, and ensuring fairness and consistency in the disciplinary procedure, promotes a progressive societal value for the public. It fosters positive cultures, encourages a fair and transparent approach to societal goals that promote confidence and trust. What remains unenforceable and have limited the discipline of erring lawyers in the disciplinary procedure, and this gap within the legal community remains a major challenge for the noble profession. So how do we justify this project? Realizing the magnitude of this problem, various civil society organizations have initiated programs and projects aimed to strengthen the rules of professional conduct 2023 that will improve the ethical standard of lawyers. One major approach is to conduct a national training, if you like, sensitization for the lawyers within the 130 branches of the Nigerian Bar Association. This will achieve a constructive exercise for legal practitioners to engage with the reviewed rules of professional conduct, observing all the relevant provisions on the ethical conduct. This will generate a report which will be used in identifying the key factors and the key actors responsible for unethical behaviors. This national training, or sensitization, will serve as a training of trainers' works, providing for a mandatory step-down workshop in each branch of the Nigerian Bar Association. One theory of change is that the step-down training should run as an activity that will be implemented within each branch of the Nigerian Bar Association for 3 months following the workshop. Of course, ROLAC will be available to support the process. This will enable the crucial ethical conduct of legal practitioners to be entrenched as part of their mandate. It will improve the code of conduct standard for lawyers and the impunity and misconduct while strengthening the NBA's anti-corruption processes and reforms. The objectives for ROLAC include to improve the knowledge sharing and create awareness for the new rules of professional conduct for compliance, to identify the key factors for unethical conduct within the legal community, and then to increase accountability and transparency for ethical compliance within the legal profession. Mr. Emmanuel Uche is on his way. He will be joining us, maybe before the president leaves or immediately after. And, oh, he's here already. He's here. So he is going to cap these remarks since he's here. Doctor, sir, with the permission of the president, can I invite you to draw a line on this so you can make your comments? Mr. President, thank you, sir. I didn't see you coming.
That was very good. Thank you. Okay, good morning, everyone. Let me stand on the protocol already established, but recognizing our president. Good morning, sir. Okay, I bring you very warm greetings, just like he has already told you that the International IDEA is an intergovernmental organization, precisely now of 36 member countries. Not just that we're in 35 different countries, it's 36 member countries working to deepen the roots of democracy all over the world. And I want to say clearly that democracy will be dead on arrival if it does not yield dividends to the people. Democracy will be dead on arrival if it does not put systems in place that ensures safety of the people and bread on the table for the people. Safety for the people is anchored on being able to put in place an effective regime of AML, CFT, CPF, countering all the ills that want to sink our society. And some of us may be aware that part of the reason you are unable to use your ATM card for international transfers is often because Nigeria is on the gray list. The implication of Nigeria being on the gray list of the Global Financial Action Task Force is that nobody will reckon with Nigeria as a country who has capacity to handle global financial transactions. And this has very far-reaching implications. Now, for that purpose, the next mutual evaluation of Nigeria is next month, okay, to check whether Nigeria is making progress towards leaving the FATF gray list or not. And one of the key recommendations is that the NBA should be in the lead of ensuring that the fight against money laundering, countering the funding of terrorists, and countering the proliferation of small arms is in force. Doing that is ensuring that every lawyer understands the rules of their professional conduct as well as their mandatory compliance rule to ensure that every suspicious transaction is flagged so that Nigeria can become a better place. This is our objective. We want to see that by next month, when Nigeria is reassessed, the NBA can get a rounding applause as having done what is necessary to move Nigeria out of the gray list. And I am very, very happy to support this process because the president himself is committed to it. And that's why he has given us his full support. Thank you, sir, for this great opportunity. And I am sure that the NBA will never remain the same again. Moving on from here, the president has told us his plans to institutionalize the Institute for Continuous Legal Education. We are happy to support that process. And very soon, you don't have to be coming to Abuja or going to your branches to enroll and get your annual licenses. All of that will be automated. Please join me to give a rounding applause to the president for what he is doing and for moving NBA to the next stage. Thank you very much. And we, as ROLAC and the European Union, will continue to be in partnership with you. God bless you and have a great deliberation.
Thank you very much, Dr. Emmanuel Uche, Component Manager, Anti-Corruption, ROLAC. Thank you very much for those wonderful words. Gentlemen, we're moving right into the program, and the formal opening ceremony for this event is over. So the workshop commences now. Please remain seated. May I call on Augustine Ezeagu to anchor the part 2 of this ceremony. Thank you.
Mr. President, members of the National ESCO of MBA, Leonard Silkser, President, gentlemen, we are starting with a paper titled The Historical Evolution of the RPC, the Rationale for the 2023 Rules of Professional Conduct. Now, our next speaker is going to take us through the updates and key changes that have been introduced in this piece of legislation, how to understand the AML and the CFT regulations for legal practitioners. He is no other than the teacher himself, Professor Ernest Ojukwu, Senior Advocate of Nigeria. Please, a round of applause as he comes on stage.
Okay, good morning, everybody. Good morning, colleagues. Well, just 1 hour for just to refresh our minds. That's just why I'm here, not really to start on any new journey. We'll introduce the AML issues, but it's tomorrow morning that we deal with the technical aspect of the AML issues. So we'll start with the rules of professional conduct now, and maybe for 30 minutes, then we'll deal with some aspects of the AML, then we'll adjourn for tomorrow morning, when we will now deal with the technical aspect of the AML. Now, I asked them to do a slide. Why is it not up? Right. Now, let me first ask, and please be nice to indicate, how many, have you read the rules of professional conduct 2007 after the call to bar? Have you read it from beginning to the end? Is anybody who has read it beginning to the end after call to bar 2007, the 2007 rules? Any indications? Yes? 2? Yes? Any more? Okay. Now, how about, yeah, sure, please. How about the rules, RPC 2023? How many of us have read it? Yes? 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 5? Yes? 6? 7? 8? Any more? So that's where the problem starts from. That's the greatest challenge lawyers have in Nigeria, is to read. And you can imagine you as a pilot, strapped to take off, and you haven't read anything about the manual of the aircraft, but you have trained as a pilot, but you haven't read the manual. So exactly that's how we fly in our legal practice. What we generally, using the Christian parlance, call the Bible of the profession, has not been read by the people who practice it. So, yes. So you now know that we are very competent car drivers, but we don't know the traffic rules. But we say we are very competent, we can drive very well, but we don't know the traffic rules. That's the major problem we have in Nigeria. So that's where we'll have to start with. So let me just deal with a few refresher ideas so that can jump us to look at the rules with some concentration. Why is it black now? Is it because they are trying to take us to the blacklist? Oh boy, why is it black? Well, we know from law school that there are several duties for lawyers in the profession, duty to the state and duty to the court, duty to the profession, duty to our colleagues, duty to our clients. We know that very in our heart, that we bear responsibility for those duties. I wish this can be solved, because I just wanted to put up something now. These things are now remote control. Carry this Fela piano, they connect us here. We should be doing this by remotely, without you connecting on these big gadgets there. Well, let me read the first one. We have Abiru J, JS now, was formerly Court of Appeal when he wrote this. That the barrister cannot pick or choose his clients. And we know what that means, that you're under duty to take your client. we remember what the principle of English law is about that. They cannot pick and choose their client as a basic principle to start our work. You remember the principle, the cab rank rule. We know the principle of the cab rank rule. Many of us still don't actually know the basis of the cab rank rule, which is why it's used as a principle for our legal practice. So, where is the, is there something here? Okay, so that's the Abiru J. I'm sure everybody will be able to read it, at least those with glasses. A barrister cannot pick and choose his client. The cab rank rule, which is embedded in our Rule 24 of our ROPC. I'm going to touch a few of these things to refresh our minds so that when we now go back to read, we will now have focus on what we are looking for, because they are essential parts of the rules before I tell you about the history. Of course, the cab rank rule is from the cab rank. We hardly have cab ranks in Nigeria because of our indiscipline. In every place in the world, including Ghana and Accra, there are cab ranks. But here, as soon as you come out in the airport or car park or somewhere, 5 different people are struggling to take you to their car, even though they claim to be an association or whatever. So you don't know where to go to. A person dragging you, another person dragging you, somebody's taking your bag, somebody wants to take your leg to a taxi. So we don't actually have a cab rank, but in other places in the world, once you come and exit a public space like airport, train station, schools, busy places, even hotels, you see taxis lined up. And they don't have to be the same companies, but they're lined up. And the only reason why they're lined up is because they are obeying the cab rank rule. The cab rank rule is simple. Once the passenger comes out to the cab rank, the available taxi, the first and available taxi is for that passenger. That taxi will not ask the passenger the destination. You have no right to ask the passenger their destination. The passenger just enters the car, and it is when the taxi man exits his spot, when he exits this line, his spot, that he asks you where you are going to. Because that's where the cab rank rule is all about. So you are under duty to take that first passenger, irrespective of wherever he's going to. So only when you exit the cab rank that he can ask you your destination, and then you can now supply the address, and he heads off. He cannot change his mind. Even when you say you are going to a criminal dungeon in New York, he can't change his mind. He has to take you there. That's the principle of the cab rank. There are a few exceptions, and Rule 24 also provides us those exceptions in general terms, but the exceptions we have had in practice too. Those exceptions, you can relate it to the cab rank too. For example, in Dubai, I am aware that women are allowed to drive cabs, taxis. But if you come in and the cab is driven by a woman and you are a man, you cannot take that car unless you are accompanied by another woman. And so those kind of exceptions are what our Rule 24 also provides, that you cannot discriminate unless there are reasons that are permitted under the rules. So you may wish to look at Rule 24 that provides for the cab rank, which is the basic principle that you are under duty to take a client. And you can relate this when we come to AML issues as to know your source of money and fees, and know the client, and so on and so forth. So the bill continues that it is a mistake to suppose, even though you are under duty, you must accept the brief. It is a mistake to suppose that he is the mouthpiece of his client to say what he wants. That's what our rules provide. And this statement is exactly provided in one of the rules of professional conduct. You are not the mouthpiece just of your client, just because you are under duty to take him, or his tool to do what he directs. He is none of these things. He owes allegiance to a higher cause It is the cause of truth and justice. He must not consciously misstate the facts. This is provided specifically, is also provided specifically in our rules. You must not consciously mistake the facts. I hear many people when we see the lawyers file lies in court, and people say, our rules provide that you cannot do that. And in fact, it doesn't matter that it's the affidavit of the client. You need to verify those affidavits before you file it. In England and US, if you lie, just lie on in the affidavit of your client, sworn to by your client, you will be penalized, you will be disciplined for just filing it without checking it out. Here we don't do fact checks. We just file whatever we. In fact, we forge the thing for the client to write. Our rules say you cannot do that. People just assume you don't have the rules. It's in the rules. You cannot write those facts in the affidavits that are false, even though you are not the person who swore to it. It is the cause of truth and justice. He must not consciously mistake the facts. He must not knowingly conceal the truth. These are all statements of our rules that Biru just restated in this case. He must produce all relevant authorities. These are expressly stated in our rules, even those that are against him. He must see that his client discloses, if ordered, the relevant documents, even those that are fatal to his case. And we don't do that. We don't interrogate opponents, witnesses, and so on. We don't use the tools of our High Court tools. Otherwise, we'll be able to put our opponents in trouble if we do. He must disregard the most specific instructions of his client if they conflict with his duty to the court. It's stated in the rules. It's stated in the rules. But we have not been harassing our lawyers for that. But I'm sure one day we'll start. But these are all in the rules. Now I go to I don't know how you're going to get it. I want you to read this in a second and vote. And okay, it's not in vote. This is just mere discussion. I'll just ask you to say anything you like. Mrs. Madam briefs you to handle a high court case for her younger brother in a civil action. Madam paid your professional fee in full. Madam wants you to send her a report or update on the case from time to time. What will you do? I just like volunteer, one or two volunteers. What will you do? Mrs. Madam briefs you to handle a high court case for her younger brother in a civil action. Mrs. Madam paid their professional fee in full. Mrs. Madam wants you to send her a report or update on the case from time to time. What will you do? I just want, yes please. Where is our guy? There's no mic for our participants. I thought this was supposed to be a participatory program. I think there's an extra here. Yes, sir.
Yes, sir. Notwithstanding that Madam got the brief to the lawyer and paid the money in full, the report is to the client and not to the Madam. The lawyer cannot be seen to be sending a report to somebody who is not the client he's directly working for. The report goes to the client may wish to send to Madam. So the response to the Madam will be, well and good, even though you brought this brief to me, I'm obliged to send the report to your brother, who is the retained client for the job I'm doing. Thank you, sir.
Thank you. Surely, confidential. Yes, please, what is?
Yes, sir. Additionally, I have to take steps to reach out to the brother, who is the direct person, and hear from him so that I can know which further advice I can give.
Good. Thank you. Because you need to manage that person who is paying you. You can't just dismiss the person and say, look, I don't have the right to give you this report. You need to manage her. Otherwise, you lose your brief. You lose another brief in the future if you don't lose that one. So it requires the consent of that client for you to give her that report. And that is provided in our rules. But I have found that many lawyers breach our confidential rules. I've had discussions with senior, junior, middle lawyers, and I've seen the scenarios all the time. We just don't pay attention to our confidentiality rules. We don't even tell the client about the confidentiality rules. When it's in our rules, you require the consent, express consent, and it's not something you just call the person on phone. Please, can I give your sister the report? You require, the rule does not say you should have it in writing, but that's your protection. You require a consent in writing. Otherwise, that client can deny you. You require a consent in writing to start giving her reports. Otherwise, you are breaching it, and we breach it all the time. Confidentiality is the key, and that's why we fought the central bank and EFCC successfully on the money laundering matter. We used the weapon of confidentiality, but yet our lawyers breach our rules of confidentiality on a daily basis. Now, let me just drag it a little further and expand our thinking and our knowledge in the area. Now, you want to do interview of the client, this same client, and this madam wants to sit in, and the client has given you consent to allow her to sit in. What will you advise the client before you allow her to sit in? What will you tell the client? What will you advise? Anything, anybody? Before you allow her to sit in to start listening to the discussion with your client. Anything anybody can offer? Any? That extends, because the rules of confidentiality is extended, the principle of rules of confidentiality is extended in our Evidence Act. So when you look up the principle of confidentiality in our RPC, please read it in conjunction with the provision of the Evidence Act on confidentiality. That's the weapon we use against CBN and EFS, and the lawyers should know it. We cannot be protecting the system, and yet we don't know how to use it. If she sits in, and because Nigerian lawyers don't do it, but I'm sure very, very soon some of us will start doing it. If she sits in that discussion with the client, it means that anything she hears, the opponent can subpoena her to testify to it because it's not protected by rules of confidentiality. Your opponent, if your opponent gets to know that she is aware of the fact, you can issue a subpoena and force her to testify on oath against his own brother that he's paying for. So these are things you need to advise the client. So we need to understand our rules of confidentiality. And I'll extend it a little more. I've seen, I don't remember the lawyer, one of our colleagues advertised the other day, their law firm is employing, and he says he's in association with another law firm in Lagos. I don't know whether you read it. They advertise their law firm's employment in conjunction and in association with another law firm in Lagos. Many of us have correspondence offices outside our jurisdiction, don't we? If you advertise the correspondence office in the name of that law firm, if you write anything in your letterhead or your website or any information as an associate of another law firm, this firm as an associate of another law firm, you expose the two law firms to the following consequences. One, the principle of confidentiality. Anything you hear is also, they cannot disclose it. Anything you hear, that law firm is under obligation to keep it too, even if they hear it in anyhow. So that law firm must also be aware that they are under duty. If there's a conflict for you, that law firm will never take the case. If you have a conflict, that law firm will never take the case. So I have a correspondent office that I advertise, and so each time somebody briefs me, I first have to call the law firm to know if they are doing the case or any way related to it. Otherwise, you are going to breach the rules of conflict of interest. We should know all that, but we take it for granted. But they are in our rules. Oh, you didn't die, oh. What did happen? Any hope? Chai. We have to tell Afam to throw away this Pella piano. What did they use here? Can see quantity of wire there. It reminds me of Nitel, those days of Nitel. If you pay in advance, they will scramble you. If you don't pay, they scramble you. They tell you to bring their fire to reconcile. That's what we are dealing with now. Wire everywhere. You can't know the wire that's going to anywhere. If you join one, you don't cut somebody in Kano, but you are in Abao, you don't cut somebody in Kano. Eh? Is it? Oh, you don't start. Thank God. I just want. Can we have that first? Where's my guy? The vote, the Mentimeter. I wanted us to use. The third one. But they have to read the case study now. Okay, maybe I should read it. And then, if you have sent it, there's a Mentimeter link I just want you to use to do a vote for me. I want to see the result, if you can. I don't know how they're going to send it. I'm told that most of us are in chairman's group or one other group or the other that they're going to send it through. But it would be easier if we had it easy through our own digital system. And your client is Dove Limited, an IT firm that took 136 million naira loan from Skybank 3 years ago and mortgaged their property at number 3 Lekki Victoria Land, Lagos. The wife of the managing director of Dove Limited is using number 3 Lekki Victoria Land as a primary school, and the school has about 350 pupils. Dove Limited is virtually no more economically viable, but Abia State government is owing it about 350 million naira from an IT contract it executed in 2014. Dove Limited has recently, good. I'll keep reading it while you're also reading it so that those who can see it well. Dove Limited has recently informed you that they are making efforts to get through to the new governor of Abia State, and that the top contacts have strong promises that the governor will pay the debt in no distant time. Now, Skybank is threatening to sell the mortgage property of your client to recover the outstanding loan, which now amounts to 290 million. The property is valued at over 500 million, but all the attempts by your client to get his own buyer for the property has yielded no result, since the economic crunch is affecting property business. Your client's MD is afraid that the bank will sell the property and will do so below the proper value of the property. Your client instructs you to file a claim against the bank to buy time and to use any and all strategies you can think of that are legal to prolong the litigation. Meanwhile, your client is unable to raise even the sum of 50 million to pay the bank, but they can find about 10 million naira as deposit for your fees. They hope that Abia State government will soon settle their debt with them, and from there, they will negotiate, settle with the bank, and pay a balance of professional fees. What will you do? Make a choice. File the claim or refuse the brief. I have that vote, if you can get it, and I wish you can go there and vote for me. I already have one vote in. One vote is already in. Are we able to get the link? Where's that guy? Are we getting the link? Are we getting the link? Okay. Can you come and announce where the link is? Yes? It's not talking. Your microphone is not talking. Okay.
The link is on the chairman's platform. Mr. Eze has sent it, and for the young lawyers, Etaba has been
I already
sending
got
it now.
3 votes, so that means some people are seeing the link. Please, I want you to look at the link and vote, please.
The title of the link is Case Study 3. So,
Just the link. You don't need to sign in and all that. If you just click the link, it opens for you to vote. Yes or no? Yes, I will take the brief. No, I will not take the brief. Yes. We are over 200, so I expect in 1 minute to have at least 100 votes. Otherwise, we are not be a useful exercise for us to do 1 hour without participating. And you know it's anonymous, so I'm not going to see your name or your nakedness. It's anonymous, so vote please. If I can get up to 50 votes, if they had connected it easily with digital, I would have been showing you the votes as they come in. But unfortunately, everything is still manual here. So I don't want to disconnect anything they are doing now. Connect again, we'll go pay for them. Sure. More, I have received 49, okay, 50 votes now. 50 votes. 50 votes. Good. Yeah, the votes are hauling in now. So far, I can tell you the trend, but you can still continue to vote. I can tell you the trend right now. We have take the brief or file the claim, 43, no, 33. So far, 44, 33. File the claim or take the brief, yes, 44, no, 34. Good. 45, 34. So the trend is likely to remain in that gap. Now, 49, 34. So more people they need the 10 million men. Nonsense. 51. Now, 30-something, 51. Good. Now, one of the greatest cancers of the legal profession and justice system in Nigeria, in fact, apart from corruption, this is the most heinous cancer in Nigeria. Most heinous. And that's why we are underemployed. We, the biggest sons, are underemployed in Nigeria. The youngest people are underemployed because we are not reaping the full advantage of our clientele in Nigeria. There are 200 million Nigerians. Apart from the fact that the economy is said to be a little down, the service of our legal services is crucial, but we're underemployed. I know it. All of us know it. We know that we are underemployed. Generally, there are more opportunities that we are not using because the clients are not coming forward. The greatest problem why clients are not coming is because of what we do with our legal system. When you enter court, you remain there till you die. Is that not the case? Generally. You as a lawyer know that if you have a case, you know you don't want to go to court because you know you're going to waste your time. For example, Gazama lost the election and was in court for the two times for 4 years. So the second time of the election that his case was dismissed. And so he's a lawyer fighting the system, his own rules, could not leave the court for 4 years. That tells you the story. And we know this. We know that this is a cancer. Yet, 67 people say we should delay, file to delay. 43 people say no, they won't file. 60-something of us here say, I know delay is a problem, but make a delay and collect my 10 million. See, that's the problem. And this is, there are three major parts of our rules that deprecate delay. Three major parts of our rules that find delay as a crime in our rules. We know this. We are hurt by this. But we say, majority of us, we still want to delay the system so that the bank will not reap the benefit of their mortgage. What a sad thing. Now, the reason, the bank failure is our economic failures. If you were grown up when we had the major bank failures, the effect was devastating. People committed suicide. And the major reason why banks failed is because people could not service their loans. And it's a business. Mortgage is a business. That's why the banks are doing business. Why do you want to stop them from reaping from it? Why? So this is a major problem. We have not read the rules. We don't care about the rules. We worry about the consequences, but we don't care. We have not analyzed the rules. We have not interrogated it. We have not read it. We have not agreed to be honest with our rules. I'll take the next one. This is the last one I'm going to do. I'm just decided to pick a few areas to wake us up on the obligation we have to ourselves to read our rules. Lawyers cannot be driving on the road. They don't know the traffic rule. It cannot happen. 200 people sitting down here, 5, 10 people have only read the rules. How? How are we going to operate? It's not possible. How are we going to challenge Tinubu or our governors or our senators or anybody on earth? How do we challenge Trump? No. How do we challenge Netanyahu? No. We have not read our own rules. We are not applying it. We are dishonest with our rules. So I just take the conflict of interest. There are 3 situations provided in our rules of professional conduct. One is non-consentable. The other is consentable. And the other is no conflict. There are 3 types of conflict. Non-consentable, consentable, and no conflict. And those have been dubbed in general parlance red lights, amber, and green lights. So we have the non-consentable as red lights, red traffic lights. Consentable, amber lights. No conflict, green lights. You can go. We need to understand our conflict rules. So let's test our capacity in this area. Can we send the link, please? I want you to decide each of these cases, which is non-consentable, which is consentable, and which is no conflict. So I have the link, please. Link. As usual, it's anonymous, so nobody is going to be known. But vote with your heart so that you will decide by yourself. It helps you to decide whether you understand the conflict rules or not. So the first one, providing counsel to multiple clients in related matter, so on and so forth. I'm sure you can read it. Just do the votes. Just decide it once you want to do. Offering representation in a dispute where the lawyer has previously represented an opposing party. You have been asked to represent 2 parties with conflicting interests. There's 2, not O. There's an error there. On the same side of a dispute. You have been asked to represent a party in a dispute where you have a sexual relationship with one of the lawyers in the team of the opposing party. Yes, sir. Only one slide. I don't understand. Only it's on the vote. No, no, no. If you do that, you go and vote the next one. Okay, let's see. They are covered. I don't know how you have seen it. It has not properly come up. Okay. Okay, but it's actually one slide, but it has 4 slides actually for you to vote. There are 4 slides, but if you can't, at least we can do that by discussion anyway. There are 4 slides there, so if after the first one, so let's look at the first one. Providing counsel to multiple clients in a related matter.
This one? Yes. There was just one.
We have 22 consentable, 20 non-consentable, 7 no conflict. You know, it's clearly a consentable matter. It's one that requires you to inform your clients and they will give you consent. And let me say this, the rule does not say we should write down our consent, but please, in conflict of interest, get a consent in writing at the earliest opportunity. Otherwise, if you quarrel with your client, you don't deny you with that. At the earliest, because when the matter will arise, it's not during the case or matter, it is when somebody has petitioned you. And in many cases, it may be him petitioning you or his agent. So if you don't get that consent in writing early, he will deny you. It becomes he said, I said. So always get your consent in writing when this is an amber case, so you get your consent in writing. So I have more votes saying 50. Let's just run through the rest since we can't see it. The rest of them is offering representation in a dispute where the lawyer has previously represented an opposing party. That is clearly non-consentable. No matter how much you consent, you cannot do that anymore. It's a brief gone. It's gone. You cannot. You have been asked to represent 2 parties with conflicting interests on the same side of the dispute. No consent can ever allow you to do that. No amount of consent. You cannot do that. You have been asked to represent a party in a dispute where you have a sexual relation with one of the lawyers in the team of the opposing party. You must get consent. You must tell your client that babe there. You must. But we take it for granted. We take it for granted. And these rules are in our rules of professional conduct. They are not outside it. All the exercises we have done are spelled out in our rules of professional conduct in black and white. They're not strange, but we have read the rules. Now, what is the history of the rules? Why did I do that? This is to show you that though the rules is over 50 years old, our rules are over 50 years old, but yet they have instructions that if we follow, our profession will be of the highest standard in the universe. If we follow it. Even though it's an archaic rule. Our rules was based on the 1974 American model rules, American Bar Association model rules, 1974. That's where we copied the present rules from and enacted it in 2007. So by the time we enacted it in 2007, it was many decades old already. The original drafter of the rules is late Dr. Orojo, Justice Orojo, who was a close senior to me, and because I was interested in ethics, and so as a young person, he drew me closer, and all his efforts, because he had a book on ethics. So he was very much interested in the rules of conduct for lawyers. So he wrote these rules in 1988, revised it again in 1992, but the bar went into Wahala at Port Harcourt, and for 8 years, or thereabout 6 years, we didn't have a bar anymore. So when the bar resurrected again in 1998, he resurrected the rules again, and every new regime talked about making new rules, Yeah. Okay. That's plenty time now. Talked about making new rules, and it never happened until 2007, when Lawa Rabana was secretary and Olisa Bakuba was president, because they knew I was working on that rules with Orojo, asked me to really help them to get the rules in place. So what I did was to review the rules and putting the things we have been discussing for 5 years. The stamp and seal, the continuing legal education program, which was my brainchild, and so on and so forth. That's all we did in adding to Justice Orojo's rules. Maybe the advertisement, which also is one area you guys find controversial, but there's nothing controversial about it. Olisa Bakuba and Arabana Lawal felt that the rules on advertisement were too complicated. And so I had to chunk out a lot of other sub-rules from it, so that we leave it a little simpler. Those were all the major things we did with the rules. And they went to the Bar Council. After 20-something years, the first Bar Council, after 20-something years, that's how lawyers behave in Nigeria. They have an organization, an organ that's supposed to make things work. They won't meet for 20 years plus. After 20 years, that's the first time. And it was enacted as a 2007 rules. We have not amended the rules. We only reenacted it in 2023. The only aspect of the rules that was touched was the last rule on the RPC that we talked about, lawyers' responsibility to report and so on and so forth, and some definitions. Because for us to merge the guidelines on money laundering, that portion had to be moved down. That's the only thing we amended. We didn't touch the rules, RPC. No word was changed. So the RPC of 2007 is the RPC of 2023, other than the addition of the guidelines against money laundering. We didn't touch the rules. Nothing was changed. So the rules, 1974, counted from 74 to now, is 50 years, isn't it, sir? You never reached 50 years, sir? Yes, it's 50 years. It's 50 years. So, but the Americans had abandoned that ABA rules many years ago. So there have been some impetus to make new rules. In 2012, President Daoud of MBA empaneled a committee to produce new rules of proportional court in 2012. And that committee was chaired by Yemi Candidate Johnson SN. And he produced the rule. He produced a new rule, and went to the Calabar MBA conference and did a workshop on it so that people would get used to it before it enacted. We came back. The Bar Council never sat. So that died it. That died the rule. 2012, that was the only effort. There's some effort now to do another one, which was started by the immediate past president, and I hope it will be done before the end of the year, hopefully, to capture the new thinkings and make some other areas clearer. But like I said, our problem in Nigeria is not law or rule or policy or principles or statements or writings or regulations. None. No single problem in Nigeria is based on that. Rewrite the rules, rewrite the constitution, rewrite the law, rewrite the regulation. We will not solve the problem. It may help as people who are thinking, but the human being is the problem. If we have to elevate the bar, each of us must read the rules. And so that takes us to why we have. Do I pause for a question before I just do the next 10 minutes AML? Do I pause for a question or two? Question or two? Yes, please.
In respect of number two, I have a practical experience that I just had in a room before I left. Now, this was a case where a lawyer, he had filed
a claim for the claimant. Now, in the presence of him alleging to serve the defendant, he cornered the defendant and he got the brief, the whole fact, the details. That's the case of the defendant. Now, at that time, the defendant had told him, I have a lawyer, but yet this claimant's counsel engaged the defendant privately in a room, somewhere else, in the pretense that he was serving her the processes, got her own side of the story, went back to amend his statement of claim, and refiled. Now, I just realized that that is not part of what you have listed. So, wouldn't that be part of professional misconduct? Thank you.
That's one of the highest. But that one, the person will go to hell too. Hell. The problem with us is that because we are not confident in these things, because we also haven't read the rules and so on, we don't make these reports. And that is the setback we have in the rules. Our rules is based on petition or complaint. In other places, professional discipline is not based on reports or petitions or complaints. There's always a group, a committee, a commission, whatever, a panel, that if they hear rumor, as I've heard now, and I'm assuming I'm in their committee, they hear rumor, I get the name of the person, I start investigation. And if we find primary facie case, we charge before the LPDC. That's how professional discipline is done other places in the world. It is not a petition writing thing. Because our character, we don't write petitions. We don't. And so in 2012, President Dawood also asked us to do something with changing how we discipline. Because our major problem with discipline, apart from ourselves, is the next major problem is the LPA. Our LPA and the rules don't allow us to be proactive in the disciplinary process. So we drafted a bill called the Legal Services Commission, which went to the National Assembly. And of course, when that happened, I'm pointing at you. When that happened was the end of his regime. It was December 2011, January, February 2012. So we took it to the next meeting of April or February, yes, February or thereabout, and it was approved and sent to the National Assembly. So of course, by April, May, an old president is out, so he's no more interested in what's happening. The next president was Okewale. The National Assembly called for a public hearing of the bills. We sent 3 bills, actually, at that time. The Legal Practitioners Act, Legal Service Commission, and Legal Education. Legal Education, we separated the council from law school so that the law school can be run with some oversight and so on and so forth. The 3 bills went to the National Assembly. The National Assembly only called for a public hearing on the LPA. And we did that one hearing, and all the bills died. So the Legal Service Commission got stuck. The Legal Service Commission has done in many places in the world, Australia, Britain, everywhere. That commission, they hear rumor, they read something in newspaper, they read on WhatsApp some gossip about a conduct. They begin investigation. They call the lawyer. I say, answer. If they find primary facie, so you don't wait for people to start petitioning and complaining. This is our greatest challenge. We have a new LPA now, which we have drafted. Now collaborated between the bar, the Board of Benchers, and the Minister of Justice, Attorney General's office. And I hope he will move it forward. We have submitted the compromise bill, and in this compromise bill, we have created a committee that will be giving such proactive actions. So I told them that if we achieve that, it will be a great leap for the ethics problem in Nigeria. Any other question? Otherwise, yes, sir. Yes, sir. Our director. See the mic behind you. Yes.
Thanks, Isaac. Good morning, Prof.
My director.
My great pleasure, and I just felt I should add my 5 pence advice to the bar. Listening to you is quite inspiring to know that we have this institutional memory untampered with on the journey to where we are so far. And while I was raising my hand, wondering whether I needed to really intervene, you struck the hammer right on the nail of what I wanted to say as to, number one, why it may be difficult and why it is that members of the most learned profession in the country will not be conversant or even take interest in, acquainting themselves with the rules that guides their practice. Why would it be so? And then we talked about, even if they know about it, so what? And here we're saying it does not matter how many laws and rules are in place, to the extent that there is a shortfall in enforcement. You will agree with me that consequence or the lack of it is the only incentive for anybody to comply, to be law-abiding or otherwise. So you then struck the nail on the head, and I was going to say, even if we don't hold this sensitization, if the disciplinary procedure is up and running, and the committee that you mentioned that will proactively look out for infractions, malfeasance, and misdemeanor among the lawyers in their conduct and seek to punish same, every other person will sit up to know how not to err. And in my advice to the anti-corruption agencies whom I serve as lead consultant to, I make it very point to them, I make it point clear that one lead indicator you need to report against that will change everything in Nigeria is the number of non-petition based corruption cases investigated and prosecuted. That's number of non-petition based, intelligence-led cases investigated and prosecuted. And that applies also to the NBA and to any profession for that matter. And if the NBA does not get it right, the bench can never get it right. Yeah. Because the bench, the bar feeds the bench. That we know. Yeah. And therefore, I sincerely want to join you to say we not only need to sensitize people, we need to ensure that people's feet are put to the fire. In Nigeria, one madman, and I mean a mad one, with 1.5 legs, standing in the center of the chaos in our country, in the center of traffic chaos, you will see everybody obeying. You get a little boy from NDA, just put a uniform, military uniform on him, without any rank, and a koboko only. Put him at the center of the traffic chaos, and everything will straighten out. Everything straightens out. Sure. Why? It appears we prefer koboko crazy than democracy. Sir, let us put in more enforcement to ensure people read the rules and people apply.
Thank you very much.
Thank you very much.
Yeah. In fact, when I was young, this one don't become Obanje here. When I was younger in Aba, I didn't use Koboko to control traffic. Then they had the Nokia, not 9 Not, the satellite Nokia. The large, big, that's all you need to hold. And one that wasn't working on some Nokia phone. That's all you need to hold, and people will think you have power. Just once I hold it in the center of Okigwe Road, everybody obeys me. That's all. No, you don't need. Because then, red light meant nothing, because they put red light for traffic light. And so one man came on radio and was saying, look, Aba people, what's wrong with you people? When it is green, Aba is moving. When it is yellow, Aba is moving. When it is red, Aba is moving. Shall we put black for you? That's how we are. More than half of the problem lie with us as a profession. A profession that cannot create its own atmosphere for thriving. In 2004, we drafted a new LPA to tackle discipline. 2004, he went to the National Assembly and died. In 2007, we drafted another, 2004 under Wole Olanipeku, our chairman. 2007, we drafted another LPA under Olisa Bakoba, our chairman. He went to the National Assembly and slept there. In 2012, I wasn't chairman, I was a member under Dawood. We drafted another LPA. He went to the National Assembly and slept there. In 2018, under Mahmoud, a large committee where we assembled everything, spent 1 year, went around the country, did conferences, drafted a very powerful new law. And there too, we tackled discipline. That one didn't go to any branch. No, he stayed in Mahmoud's laptop until he left. Now, so, yes, please.
Yeah.
Yes.
Prof, yes, my take is on the case of mortgage. You see, the contention there is either you file a claim or you refuse it. But I think the problem is if a claim comes to you and you know what you're doing and now gives you a case, as a professional, you're supposed to advise your client on the best way to handle the matter. For instance, in that matter, what I would have preferred is, first of all, to go for a negotiation, not to talk about filing a claim or refusing it. Now, in the event of your advising your client, and probably he refuses to accept your honest and candid advice, which is proper, at that stage you should leave the case. A client should not dictate for you how to do your matter. So, for a client to come and say, file a claim, when you know that if you file the claim, it's going to fail. So far as I'm concerned, it is also wrong. And it is wrong for that lawyer to accept a claim that you know that you go and file for purposes of filing so that you can get money. Yeah. Because you can also get your money whether you file a claim or not. Sure. Because if you go for negotiation and talk to the people, there's a way that matter can be resolved than filing a claim. So, Prof, sir.
I can just summarize since I have now.
I'll just summarize, sir. So, to me, it's for the lawyer to make sure that you advise your client, and if he refuses to accept your candid advice, you should drop that particular matter.
Thank you very much. I didn't want to expand it to those discussions. I just wanted to highlight. It's not a fictional case. This case is not fiction. The only things that are fictitious are the names of the parties. This case is exactly what the client asked the lawyer to do. And the lawyer did it and filed this claim in 2017, 2016. The case is still in court as I speak with you. The bank went down at that time. The case is still in court as I speak with you. And you can see as one of the accumulation, apart from the corruption of directors and managers of banks, you can see that the main problem with the Sky Bank was the portfolio of loans that were unrecoverable. The case went, this one is not Sky Bank, but I just gave you that example, yes. So on the AML, I promise that tomorrow is the technical day in the morning, 9 a.m. for us to give you answer. Okay. You can just do the brief because I have now 5 minutes to go. Yeah.
Yes. My question is on the first, Mrs. Madam's group.
Yes.
About the younger brother.
Yeah.
Now the younger brother refused to give consent.
Right.
And then Madam now said, if you cannot send report, the one that brief you, leave the case, you are the brief.
Then you leave the case then.
Thank you, sir.
You ask your client, do you want to leave the case? But remember, you have paid their fee in full. If your client is okay with you leaving the case, you leave the case. But remember, you're going to refund some money. Even though it's them that want you to leave, you still refund some money. Because if you have not earned fee, you have not earned it. There are some petitions we came across in that made prima facie case where it's not the fault of the lawyer that he did go further. It was fault of the client, but the client could not provide it, and now thereafter asked for his money to be refunded, and the lawyer says, "Now lie, I've earned it." So the fact that you have, it's not your fault that the case didn't go further, does not mean that you have earned the money. You must do quantum merit, and so we can agree on which parts, if any, that have not been used was a large consideration. And if you don't return it to be a misconduct, as we have seen in some cases, lawyers didn't know that to advise them, and happily they made it paid back. We found prima facie case against the lawyers, but we recommended no prosecution, since they were able to agree that it was refundable. So that's just that. So the AML, I just want to give you 2-3 highlights. Then tomorrow we'll do the technical part. 1, remember there are 2 cases from the bar and from a member that set aside certain provisions of the Money Laundering Act. Many lawyers assume that because those provisions have been set aside, that the Money Laundering Act does not apply to lawyers. Foul, as masquerade, Zebodiah would have said in his masquerade. The Money Laundering Act applies to lawyers 100%. 100%. Let me illustrate it. There are 2 types of crimes, 2 major types of crimes of money laundering. One is the substantive, traditional money laundering crime. By taking money from a system illegally and hiding it. That is the substantive, traditional money laundering crime. And that is what the Money Laundering Act is fighting against. That crime applies to everybody, including those unborn. So the act applies to you as a Nigerian in Nigeria. You are completely regulated by the Money Laundering Act. So as a lawyer, if you commit money laundering, you will deduct. No provision has been removed for the application of Money Laundering Act against any lawyer. The second type of money laundering crime is the reporting crime, what we call the reporting crime, money laundering crime. The Money Laundering Act wants to prevent money laundering. And so to prevent it, based on international standards, reporting processes have been put in the act for certain designated non-financial institutions to, in addition to financial institutions, to make reports from time to time in order for the country to prevent money laundering. That reporting crime covers reporting on currency reporting, or suspicious transaction report, or those on the sanctions list. Criminals who have been, especially terrorists. There is a sanctions list. There's an international sanctions list. There's also a Nigerian sanctions list. Those are the 3 reports that the non-designated, non-designated financial institutions say to have the obligation to file reports from time to time, in accordance to the Act, in order to prevent money laundering or help to find such crimes and charge it. And that is the part the Nigerian Bar Association say
and we stood by it, that we will not report to, any agency. Are you getting me? We shall not report to any agency because of our confidentiality protection. Though a ordinary statutory provision has a constitutional backing in fair hearing, without confidentiality, clients will not be coming to us. You can't fight justice. And so it's embedded in fair hearing principle. So that's why the courts agreed that, look, lawyers cannot be made to report to these agencies because it will offend our principle. And that is those provisions the court struck down our reporting obligations under the Money Laundering Act. That is all that was struck down. So as lawyers, as law firms, we are no more going to report to SUML, NFIU, EFCC, Central Bank, anyway. We're not going to report to anybody. And following the trend among many countries of the world, including the US, the bars, the ABA fought a statute that was attempting to put lawyers in their law. They fought it instantly, and so lawyers were not included in the designated non-financial institutions in the US. Even though lawyers make reports of certain transactions, but not as designated non-financial institutions under the Act. Canada passed a law including lawyers to report. The lawyers went to court and set aside the provisions relating to their reporting based on the same principles of confidentiality. A couple of other countries also don't report to any agency that way. So in this area, in these places, the lawyers alternatively say, we shall report to ourselves. Self-regulation. And that's why we created the Anti-Money Laundering Committee and passed guidelines so that we shall report to ourselves. Self-regulation. And in the guideline, we removed the 1 million reports that the Money Laundering Act provides. You'll be spending the whole month doing only report. We removed all those reports. Nonsense. And only restricted it to risk assessment, risks. And therefore, we are only obliged to report risks. Suspicious transaction report. We removed currency reported, we removed other reports, and only left suspicious transactions report. There are other things you are obliged to do to prevent money laundering. And that the technical aspect we will highlight tomorrow morning. So we don't put everything together and stuff our heads and don't gain anything. What you should take away from the Money Laundering Act or our money laundering guideline is that if you take the steps to do the activities provided in the Money Laundering Act, the law presumes that when your client commits money laundering in certain respects, prima facie, you are not involved. That's what reporting gives you. Prima facie, you're not involved. But if you don't file those reports that are supposed to file, and the case becomes a money laundering act, the law will assume that you are involved in money laundering. So I hope in the morning, 9 a.m., I'll be here as early as 9 a.m., but we can just take a few of these technical aspects and explain them for ourselves. But otherwise, if you have any questions generally on money laundering or anything else, I think I still have 5 minutes, 2 minutes, no minute at all. But you have to borrow them minutes now, borrow them. At least one, you can't, I can't just walk away now, you know we're good like that. Yes, please. So somebody is right there, right there. If you have good voice, right, the mic is coming down. Who don't have the mic there? The mic don't go then. Mic is yours. Okay.
And the question is contention of interest, sir. During your presentation, sir, you mentioned correspondency That's of any dispute, assault or group. So my question here is, in the situation or hell, uh, strangers or no from future, fundamental state, I call or thereabout. Clients now, respondent, defendant or thereabouts, actually, they are two decision of the high court for who? For example, there are two defendants. We present the first defendant on behalf of the other lawyer. Then, in the appellant court, it is the plaintiff that was unsuccessful in that matter. Decision. Please, I want to know the conflict of interest, whether or not conflict of interest can arise at that instance.
Now, last year you come out for the case.
Yes, everything.
They announce, even if you don't get the file, as many lawyers will come and announce they don't get file, though. You don't come out for the case since before you were born. You don't come out. I think that one answers it. Thank you very much.
A round of applause for that. So, real quick, if you have a red Honda, so please SF 798 DE, we need you to please go and repark. It's very important. Yes, please. SF 798 DE, please go and repark. Very quickly, while Brother Silk was delivering his paper, some members of the National Exco came in. I saw the first Vice President, Sebastian Anyu. Thank you. She's out there. Please, for all of us. Front treasurer, she's seated up front. Now the assistant police secretary, she's here in front as well. Our host chairman, Steve Omele, is a chairman of Unity Bar. Please, a round of applause for him. He's trying to take care of you guys in the proper NBA tradition. We're going to go straight to the next session, lawyers and the RPC, an overview of the role of the LPDC. So real quick, I'll introduce the panelists. Ms. Ayodeji Oni, she's the Director of Bar Services. Please, a round of applause. We don't want any issues, our staff and sales. Let's applaud her, please. We have my dear friend with Dr. Chinedu, please come on stage. Then Mr. Zibai Blessed Katungi or Katung. I hope I got that right. The Assistant Secretary of the LPDC. Taking us for the next 1 hour, and please let's pay attention. This is really important. Thank you.
Hello, good afternoon, everyone. we will stay and we will establish the existing protocols. So I'm going to start asking the question from Mr. Katung. Are you okay? Well, I will say this. In the MBA, our core values are integrity, professionalism. Okay. Okay. At the MBA, our core values are integrity, professionalism, courage, and excellence. And for me, I see that as a very good attribute that an individual can have. So what do you think about it in terms of what is going on at the LPDs and all the cases that you handle on behalf of lawyers?
Okay, thank you very much. I subscribe to these values that you have just stated. At the LPDC, basically the functions of the LPDC simply is to deal with cases of professional misconduct by lawyers. And I believe as lawyers, there are certain ethical standards that should guide our dealings with our clients and with the society in general. So once we don't have these virtues, you've said, excellence, integrity, and all, then basically there's a problem. And the role of the LPDC simply, like I said, is just to ensure that there's discipline in the bar. And so the LPDC and the NBA working hand in hand together, I believe that these virtues can ascend if we try, sorry, let me just bring us back to, I was seated when the Leonard Silk asked how many lawyers here have read the RPC. And I think only 6 hands were raised. So it raised a question, how are lawyers supposed to act if you don't know the rules? If you don't know the rules that govern your conduct, then there's really a serious problem. And this is what we've seen at the LPDC. The lawyers will appear before the LPDC and they don't know what is expected of them. They don't know what is expected of them. I'll give you a clear example. Just in June 2024, a lawyer appeared at the LPDC. He stood an action on behalf of his client. And then during the course of the hearing, he announced his appearance, adopted the affidavits of his clients, and then the other lawyer said he wanted to cross-examine the witness of the client. And then this lawyer stood up and said that he was the witness. And then the committee asked him, you applied on behalf of the applicant? He said, yes. You are the counsel for the applicant? Yes. You are the witness for the applicant? He said, yes. And then the committee drew his attention to Rule 20 of the RPC 2023, and then asked him to reconcile his conduct with Rule 20. And then the lawyer simply told the LPDC that he was not aware that he could act both as a counsel and a witness for his client. And immediately the committee found him liable and suspended him for 5 months at that spot. Wow. So it's important for lawyers to read those rules. It's only when you read those rules that you know what is expected of you, and then you'll be able to guide your conduct.
Thank you very much. Dr. Chinedu, with your 21 years experience practicing law, I would like to speak a little on professionalism and excellence of a lawyer.
Thank you. Okay. I want to say that if a lawyer must show that he's a lawyer, he must wear the garment of integrity. Integrity is a bogus language.
if you look at who won, have more really changed from 2007 even till date. The one is very important of the RPC. Talks about your integrity, your comportment. Now, I want to look at it from the angle of the LPDC and the RPC. First, the LPDC is a creation of the LPA, which is the Legal Practitioners Act. The RPC is a creation of the LPA, which is the Legal Practitioners Act. Who makes the rules for LPDC? Who makes the rules for RPC? The LPDC is a committee of the body of benchers. But interestingly, the rules governing the LPDC is not made by the body of benchers. This LPDC is made by the CJN. I'll take it again. The LPA created the LPDC, Refinery Committee, but the rules used in the proceedings by the CJN. Now, what will the LPDC be doing? The LPDC's role is to enforce the rules of professional conduct. Rules of professional conduct is made pursuant to the LPA. The rules of professional conduct is also made by the body of benchers. The rules of professional conduct is made by the General Counsel of the Bar, which is headed by the Attorney General. I don't know whether I'm communicating. Now, if you have I feel that there is a level of independence so that the LPDC, which is the body, which is the committee of the body of benchers, which is some level of independence. Without sounding like a broken record, every lawyer is strictly bound to know what is contained in the RPC. And the unfortunate thing is that the punishment to be handed down by the LPC, as far as I'm concerned, is discretionary. It's not like the criminal code which says if you steal, it's punishable by 5 years. If you, it's punishable by 2 years. It's discretionary. What the law says is that as the panel, the LPDC speaks. I'll leave it at that for now.
Thank you very much for your contribution. I will still ask you another question. At the NBA, our motto is using the law as an instrument of social change. Do you think these laws, LPDC law, LPA, and the rules of professional conduct, is it apt for such? Is it driving the use of law as a social instrument for our professionals? You want me to take it?
I understand the question, unless for the benefit of the audience.
Okay. Our motto at the NBA is we're supposed to be using the law as an instrument of social change. have the LP, we have the LPDC rules, and we have the rules of professional conduct. Do you believe that these rules are apt for these 21st century lawyers? Are we meeting that need in terms of using it to influence the professionals, to influence so that we will have more ethical standards and value within the society?
Thank you. I think the rules are apt. Why do I think so? Why it looks like new things are being introduced, why it's difficult is that we have over time failed to continue to educate ourselves on these rules. To start now, it is not late. And for instance, the 2023 rules, if you look at the rules, it's very interesting because it now has 3 chapters. Everything that used to be in chapter 1 of the RPC, everything that used to be in the whole of the RPC is in chapter 1. Everything that you know as RPC before 2022, before 2024, is now found in chapter 1 of the RPC. So what is in chapter 2 and what is in chapter 3? So what it also means is that anybody that is seated in this room, that if the last time you looked at an RPC was when you prepared for finals, that you need to go back to look at the RPC. Chapter 2 is on anti-money laundering and anti-terrorism financing. I will not, I think Prof has a session on it tomorrow, but if you insist, I may mention some of the things that, if you look at that chapter 2, for instance, if you look at it from, what I call it, from an opposing angle, you have a lot to say. But if you look at it as a law that have come to stay, then you'll be thinking of how do I comply? The bad news is that it has come to stay. So we need to find out how we comply. There are cases because of discussing it with someone quickly jumped at what they call it, Ozokema and EFCC, that are only duty as to it's not my business to find the source of funds where the man is paid from. But there's also in Sameto and EFCC, which also says that Sameto ought to know that suspicious. So there is a balance. There's a balance. So you must know. I'll give you another example. If I'm engaged by the MBA president in his private capacity to do a land matter involving him in Sokoro, and when he wants to pay me, I receive a lot from. Soothsayer to know that there's a suspicious transaction. So the question is that you are now duty bound to report suspicious transactions. But who do I report to? The RPC is the current RPC, as far as I'm concerned, still has the lawyer's interest at heart. It stopped the lawyer, as Prof said earlier, for reporting directly to the agencies. But if it is reporting, the lawyer must report. Thank you.
Thank you very much, Dr. Benu. Mr. Councilman, please, we have our branch chairman, our young lawyers here. I would like you to give us an highlight of how to apply to report a lawyer, because I'm aware that as part of the LPDC 2020, a branch is also obligated they can file a petition on behalf of their branch to report any professional misconduct. I'd like you to give us more information and more highlights on it so that they'll be properly guided. Thank you.
Okay, thank you very much. Based on before the 2020 rules, we had the 2006 rules. And under the 2006 rules, it was only the Nigerian Bar Association that could prosecute matters at the LPDC. And those rules came into effect in 2006, and that was the law until 2019, when the Supreme Court gave the decision in Obiajumo versus NBA and the LPDC. So there were certain issues the Supreme Court had with the way matters were brought before the LPDC. For example, all you needed to do was to file a prima facie case, and then the General Secretary referred it to the LPDC. And then when it gets to the LPDC, the Assistant Secretary of the LPDC will tender those documents, and then the lawyer will be asked to enter a defense. But the Supreme Court said no. The Assistant Secretary wasn't part of the investigative body, so that evidence of the Assistant Secretary is hearsay evidence. And then they went further to say that at least you need additional evidence. And so, because of this change, the LPDC sat down, and then there was a stakeholder conference, and then invited people, and then they gave certain suggestions. So the rules changed. Now, the NBA can file actions at the LPDC as the NBA. Incorporated trustees of the NBA, because based on Moses versus the LPDC, the Supreme Court held that the NBA was in a juristic person, so it has to be the incorporated trustees of the NBA. The NBA can file cases directly at the LPDC. They can also file on behalf of, I think we have instances where the first vice president on several occasions filed petitions against certain lawyers at the LPDC. That is also allowed. Under the new rules, anybody can file a petition at the LPDC. Anybody, there's no restriction. At the LPDC currently, we have men filing petitions and doing their cases successfully. There are instances where, of course, they can't file, they file written addresses, but of course, without cases. And they've been successful. So as a branch, you can file an action in the name of your branch, or you can just simply file through the incorporated trustees of the NBA directly, or you can file as an individual. Because as a stakeholder in the legal profession, you also have a right to report certain conducts that you think are unethical. So those are the dimensions.
Okay, thank you very much. Dr. Ben, would you like to make a comment on that?
Okay. The rules used today in the LPDC is the 2020 rules, which revoked the 2006 rules. Now, there are changes in that rule which do not really go down well with the NBA. One of such changes is that the investigation rule that the NBA had under the 2006 had been taken away. What the implication of that is that it has been taken away, and even LPDC. So the LPDC investigates, establish a prima facie case, and then sits as the judex over it. So that is a very big problem with the 2020 rule of the LPDC. Now, that rule also did also not make it mandatory for NBA to be a party to proceedings. Now you are investigating a lawyer, prosecuting a lawyer for disciplinary conduct, and there is nowhere NBA is in the matter. Now, where is fair hearing in the proceedings? In fact, the rule is saying that when the is reported, when the originating application is made, that the chairman can nominate one of the panel members to look at the complaint. One. Then he can now nominate three if the person fails to if the person fails to certify that there is a prima facie case. Three to look at it. All members of the same panel. I think that the NBA is working towards, or should be working towards, either a total reversal to the old rule or an amendment to it, because as it stands today, the LPDC is both the investigator, the person that establishes, the body that establishes whether there's a prima facie case, and the body that also prosecutes you. Now, the interesting part of that thing is that when the LPDC is investigating, they can do away without calling even the respondents, the lawyer, respond to the allegations against him. The LPDC, under the new rules, is empowered on its own without bringing in the lawyer's view. The lawyer whom the case is against, the LPDC can decide there is a prima facie case against him. This is the investigation. So it means that as it is today, before that law is changed, that the standard of conduct expected of you and me should be higher than what it should be. My advice is that ending the time that rule is changed, stay away from profit.
Thank you very much. Before Mr. Carson responds to him, I would like to ask you another question. I'm aware that we have a standing committee. The NBA Constitution stated that Ethics and Disciplinary Committee should be a standing committee of the NBA. Don't you think that the standing committee should be working with the LPDC to ensure that the rules are properly and duly applied? I would like to hear your opinion on that.
I'm not sure whether I clearly understand your question. Okay. I didn't say the NBA is not involved. I said NBA must not be a party. Now I can approach the LPDC, or the NBA. Ordinarily, it used to be under the 2006 rules. There are 7 categories of persons to whom you submit your complaints to. The CJN, the Chief Judge of a state, the NBA President, the President of Court of Appeal, the Presiding Judges of Court of Appeal, the branch chairman. There are about 7 of them. Now, they submit they followed your petition or complaint to the NBA, and NBA will investigate. May I state that all the rules, the same category of persons can also receive complaint. But the only innovation there is that they must transmit it within 30 days, which did not exist under the 2006 rules. And maybe a party, I think Statella is your documents. It's cartoon that says that MDA can bring. MDA can bring because the one that the other person has brought. That's what I'm saying. So MBA must not. If I choose to join the MBA, thank you.
Thank you very much. Mr. Kantung, would you like to respond to what Mr. Dr. Obianis?
Okay, thank you very much. Like I said, before the 2020 rules, we had the 2006 rules, and that rule, we repeated that rule for quite a number of years before the decision of the Supreme Court. And like I said earlier, Obiajulu Walutu's case brought up a lot of issues. You know, for example, I said during prosecution at the LPDC post 2020, what to do was to tender the bundle of documents from, the investigative panel showing that there was a prima facie case, and then the documents the committee considered in coming to that conclusion. And usually once the LPDC gets that document, like I said, we tender it, and then the proceedings will continue. Now, the Supreme Court, in their wisdom, felt that that evidence alone is not sufficient. You need additional witness. And the issues in the past simply is all the proceedings of the LPDC is here in Abuja. You have parties scattered all over the country. They have difficulties presenting their witnesses to come down to Abuja. Some will complain they don't have money. Some will tell you one reason or the other. Some of the primary complainants were intimidated by lawyers. So they file a petition, and then when you tell them, come, it's time for us to prosecute, they don't show up. So that affected the proceedings of the LPDC. At the end of the day, it was only the evidence tendered by the Assistant Secretary that would always be available. Additional witnesses were not coming forth. So the LPDC looked at it and considered, how do we solve this issue? You can't force the person to come and testify, for example. And so that was why they came up with the originating application, filing of an originating application. Now, under the new rules, as a witness, you don't even have to appear at the LPDC. Your lawyer will only adopt your affidavit. And once that affidavit is adopted, that is all. Now, except for instances where the respondent now wants to cross-examine you, that is when your physical presence is required. So once it's purely affidavit evidence. So once you come in and your lawyer tenders on your behalf, then the other lawyer will also tender, adopt his own affidavit, and then they are joined for for adoption of written addresses. So with these new rules, we have found that cases can be concluded within 3 sittings. First sitting, you come, you adopt. The next sitting, you adopt your written addresses, and then the next adjourned date, direction is given. We've had that within 3 months, we've concluded matters. But I can assure you that under the 2006 rules, it took 3 years to conclude one matter. Apart from that, lawyers will come and then today, one adjournment after the other. We are sorry, we just filed something this morning and I've just been served. I need time to respond. And next adjournment is another excuse. So some of these were the issues that kept hampering and that's that necessitated these changes. Now let me respond to the issue of the LPDC being the investigator, and then also, and now, I don't know if some of us will have the opportunity of reading the rules of other jurisdiction. I think Prof is here, and maybe we are seeing that of England and Scotland. The LPDC rules 2020 is a replica of the rules in England and Scotland. Same thing also with the Philippines, with Kenya, with South Africa. That is the standard rule now. So the LPDC simply looked at those rules and then adapted it to suit our own, unique situation. And I'm hoping that somebody will challenge this issue of them being the investigator and the judge at the Supreme Court, and then it will be interesting to know what the decision of the Supreme Court will be. Even though, if you remember Ganifa versus LPDC, it was almost the same allegations that was made. Back then, we had the investigative committee, and then we then had the disciplinary body that would then they were the same two bodies in one, and the Supreme Court said that it was wrong. But looking at the current rules, it will be interesting to know what the decision of the Supreme Court will be, seeing that they are responsible for the change. So until that is done, with respect to efficiency, these current rules are more efficient than the 2006 rules.
Thank you very much. In light of that, I would like you to give us like statistics, figure in a year. How many cases does the LPDC handles in a year, for instance?
Okay, so in 2022, let me start from the current, from the tenure of the current chairman of the LPDC, Honorable Justice Dr. Ishaq Bello. From 2022 till date, in 2022, the LPDC received 281 petitions, originating applications. In 2023, we received 253. And then last year, we received 314. So far this year, we received 28. And out of these cases, from when Honorable Justice Dr. Ishaq Bello became chairman in 2022 till date, the committee has given 64 decisions. Now, yes, somebody might say that's not really, but the LPDC has its own unique challenges. For example, the Legal Practitioners Act has provided for 11 members of the LPDC. And to be honest with you, this work cannot be done by 11 people. It cannot. It cannot. And who are the members? The President of the Court of Appeal is one. A very busy person, there's so many cases, so many administrative duties, and you have a member of a disciplinary committee that sits regularly. Of course, there will be problems. You have two chief judges. They have a lot of cases on their docket. They have administrative duties. There are two attorney generals. They are political appointees. For example, if we are sitting and the governor calls his attorney general and says, I need you now. The attorney general will leave the LPDC immediately because he's a political appointee and he's answerable to the attorney general. So these are some of the issues. So there's need for a change in the composition, in the membership of the LPDC. We can take out this, this restrictive description we've given the members and then leave it open. The LPDC can have 25 members. 30 members, divide them into panels. The current law says the quorum of the LPDC must be 5. And 5 that start must be the 5 that would finish. That also has problems. Assembling 5 members at the same time is challenging. But you see, the LPDC rules have provided for 3. But then, the primary act is the LPA. So we have to amend the LPA to also reflect that number of 3. If you have 3, is a manageable number. At least 3 people can sit and then consider such petitions. And then another thing also that can be done is, LPDC should not sit only in Abuja. Respectfully, LPDC shouldn't sit only in Abuja. With the cost of air tickets and how dangerous it is to travel by road. It's not safe for everybody to assemble in Abuja. So you can have divisions. Maybe have the LPD sitting in Abuja, in Lagos, in Port Harcourt, and then once they just go there, you sit, and then you finish, and then everybody is back. Prof actually made some suggestions recently about having members of the body of benchers. Let's say you have members of the body of benchers in Aba, for example. You can just do a panel of 3 of those members, then all the cases emanating from Aba, give it to them to finish. Once they finish, you dissolve. The same thing also for Lagos. You can set up 2 or 3 panels of the LPDC in Lagos. The members of the body of benchers will have a lot of members there. They can sit, listen to these cases, and then dissolve when they finish the docket given to them. So I agree that, yes, the number is small, but at least for now, due to these restrictions, we have to make do with what we have until we have amendments to the law.
Thank you very much, Mr. Kasong. I would like to say this again. The Nigerian Bar Association, we have a standing committee, ethics and discipline. What role do you think we can play in ensuring a speedy justice for the system? Thank you.
Okay, thank you very much. Recently, I was a part of something when the discussion with the body of benchers to come up with suggestions on how to amend the Legal Practitioners Act. I was opportune to be one of the people present. Prof was also there on behalf of the NBA. And this particular committee, I think in his presentation, we also said it. We don't have to wait until certain things happen. Once you hear a rumor, like you said, you know that something is happening, we just call the person and said, we are hearing this, respond. You don't have to wait until you gather all the evidence, you file papers, you come and appear. No, once there is a hint of anything, you simply just go ahead and then invite the person to you have to be proactive to the person to respond. Now, the issue of prima facie finding is a serious issue, and I believe the NBA still has a role to play in the issue of prima facie findings. This ethics committee, for example, can simply just sieve through petitions that come to the NBA. And if they look at it and then they feel that there's a prima facie finding or there's substance in any of those petitions, forward it to the LPDC for prosecution. I believe that having a multifaceted procedure or people who can do this job will be better than restricting it only on the LPDC. As the years are 2020, the NBA still can play a vital role in investigation and also presenting cases at the LPDC. I don't know why the NBA are not. I don't know why the NBA has refused to play that part. But the rules 2020 has clearly spelled out the role that the NBA can play. I think that the NBA should take use of that of this opportunity to still present cases. Thank you.
Thank you very much. Dr. Obreno. Mr. Katun just challenged us now that we're not really making good use of our ethics and disciplinary committee. Before you respond to his comments, then I would like to hear your opinion on this. I know you are the secretary of the LPDC Watch. I would also like you to highlight your roles, your responsibility, and how that will affect the profession. Thank you.
Thank you, ma'am. Let me start by agreeing with him that the LPA needs to be amended for several reasons, including disciplinary matters. I also believe that the branches of NBA have grown, the bar has grown so much that we don't need to restrict disciplinary matters only to Abuja and the security on our roads, etc. Now, when you talk about investigation, which is an area where the MBA is not happy with. And you also stated that MBA can play a role. Playing a role is different from being a stakeholder. I am part of this. I shouldn't play a role if I wish. If I'm a stakeholder, I should be on the table. Who is facing disciplinary committee? MBA, a member of MBA. It's the one that is being brought before the LPDC. So why wouldn't the MBA be involved from the beginning? I recall that there is a decided case of Kiki and LPDC. Is in 2000 and it is reported in 2004 or 2005. In that case, I can even remember the part. The part is 949, page 71. In that case, the rule, the procedure for disciplinary measures were highlighted. And the reason for highlighting it, to my mind, is to make sure that whoever is facing disciplinary measure feels that he has passed through, there's justice, that he got justice at the end of the day. He listed the proceedings for it. Reporting, investigation, prima facie case, and decision. These were the case. This was what was decided in that case. And that is a Supreme Court decision. I don't know of any judgment that has upturned that. So we cannot throw away the investigating right of the MBA. Now, the ethics committee cannot be the MBA, not the ethics committee, because the ethics committee represents the MBA. We cannot be investigating a lawyer and you tell us to, the people investigating the lawyer are on the table. You tell us to sit somewhere there and until we recognize we can't talk. That's what it means. If MBA must play a role in the investigation, let it be stated that MBA has a role to play, not only. I don't know whether I've answered your question.
You've not answered on the LPDC watch.
The LPDC watch committee, which I'm the secretary of, we are trying to, some of our terms of reference include looking at the current rules of the LPDC to see how it can be amended. Recall that in my opening statement, I stated clearly that even though the board of benchers has the responsibility of saddle with the discipline of lawyers, the rules to discipline lawyers is solely the business of the CJN. So if the MB, we are trying to see how, but we're also not unaware of the fact that the body of benchers have rules committee. We are trying to also look at how the rules can be amended. And good enough, they now know that the investigation part is an issue. And one of the things they are proposing is maybe bringing in retired judges to play the role of investigation. The contention of the MBA is that since the 2020 came into existence, less directions have been given from the complaint. If it was that the investigation was delaying the matters, but since the advent of the rules, we have had less directions than what we used to have in the past. So it means that there's a problem. It means that the rules seems to have worked better than the new rules. So we have the view that
MBA being a stakeholder on the matter. You will sit with other stakeholders and look at how these things can work better, and that the MBA, we are hopeful that the MBA will achieve that within the next couple of months. Thank you.
Thank you very much. Mr. Kason, from what I will take from what both of you have said, that there is need for the Nigerian Bar Association and the LPDC, the body of benchers, to have a proper synergy for us to have an effective enforcement of our rules of professional conduct. One of the reasons why we want this session is because we want to have practical experiences to our members so that they actually know that these proceedings are taken seriously by the leaders of the bar and the leaders within the legal profession. And therefore, our role as a lawyer to ensure that we have integrity, we exhibit excellence, professionalism, and courage all the time. It's crucial. Can you give us like a few overview on what happens when goes on and the directions at the end of the day? Thank you.
Thank you very much. I want to disagree with the statement that before now there were more decisions. That's not true. That's not true. Like I said earlier, under the 2006 rules, to conclude one matter, it will take you 2 years, minimum of 2 years. I don't know if there are former prosecutors here. It will take you minimum of 2 years, 3 years to finish one case at the LPDC. But currently, like I said, you can finish a matter within 3 months, 3 sittings. Within 3 sittings, you can. And in the past, the sittings were sometimes you can hold sittings 3 or 4 times in a year. Currently, it's almost on a monthly basis. In fact, the former panel headed by Mr. Okala will sit for 2 weeks. Monday to Thursday, 1 week, one panel, the following week, Monday to Thursday, and the matters were going on from day to day. Now, some of the practical issues, like I said, the issue of discipline is very, very, very important. Now, at the LPDC, for example, we've had, there are diverse views on what conduct should be punishable. You made mention of the fact that the decisions of the LPDC is at the discretion of the committee. I agree, that's correct. It's based on the individual case. For a particular facts for a case, for example, they can decide to suspend you for 2 years. In another case with almost similar facts, the punishment can be to disbar you completely. I'll give you an example. In a recent case that was concluded last year, the lawyer collected money to do certain things for his client and then failed to do it. And then filed a petition at the LPDC. And then the committee of the opinion that yes, the lawyer did not do what he was asked to do. But immediately the applicant discovered that the lawyer failed in his duty, he quickly took steps to remedy some of the inactions of the lawyer. And based on that, he felt that at least the client has at least gotten some reliefs. And then ordinarily in such cases, minimum of 5 years, they suspended the lawyer for 2 years. So what amounts to professional misconduct, to be honest, is I don't know. For example, a lawyer was found liable for inserting a date in a motion. And this is something a lot of lawyers do. You file a motion in a court and then you insert the date. Both of them, their names were struck off for inserting a date on a motion paper. There are other examples, and most of the cases we have at the LPDC, they are 90% of the cases are money-related cases. You collect money on behalf of your client, and then you don't remit the funds immediately. You hold on to it. And then when there is a request for you to give, lawyers will come up with, I have a loan, there's a loan on those funds. And the LPDC has ruled severally that a lawyer does not have a loan over the funds of his clients. As a general rule, but there are certain exceptions to it. If you collect money, the first thing to do is, of course, have it in your client's account. And then second, promptly inform the client that I have received this money. Tell me how to proceed further. Or just send his money over to him. If you are still agreeing on what your professional fees should be, for example, if in the course of your conversations or in the process of negotiating, of course, written, you have said, okay, fine, I'm entitled to 10%, and then the client says, no, I think you should be entitled to 7%. Okay, let's wait until the funds arrive. Then you can hold on based on this written agreement. But once the money gets to you, what you should do immediately is to send him his money. The LPA is clear on how lawyers can get their professional fees. But I believe a lot of our colleagues are not patient enough to go through that process. And so they hold on to these funds. And so many times, they find lawyers liable for that. Another very touchy issue is lawyers selling land on behalf of their clients. It's a very complicated transaction. And we've held severally that a lawyer has no business selling land. Selling of land is a duty that is incompatible with the status of a lawyer. Shouldn't some also manage their property? A lot of us do these things, but as long as there's no problem, fine. But the day anything comes up, a day that a problem will come, because, like I said, about 90% of money related. And part of this money related issue is selling land on behalf of your client. You sell and then you say your percentage is this. And sometimes lawyers want to charge on behalf of their client and then also fees both for buyer and seller to do agreement for, and then act for both buyer and seller. These are some of the very, they seem innocuous, but they are very serious issues that lawyers need to be very careful about. And then recently also the committee has said issuing cost, because we have the issues we have in regular courts. Sometimes lawyers forget that the LPDC by itself, but the duty to the court is the same duty that you owe to the LPDC. And so you find that there are delays in cases. You come to do one adjournment after the other, one adjournment after the other. And then the committee decided to start issuing cost. And not only for the client to pay, but the lawyer representing whoever is responsible for that delay, you pay personally. Just on the 21st of January this year, when the committee met, the matter was adjourned. The last sitting was held in November. And then the committee was supposed to sit in January. The lawyer for the applicant did not file a response until the day of the sitting. And then the committee didn't take that lightly. And then they fined the lawyer $500,000 to be paid personally by him to the respondent. So these are some of the, and like I said, you might think you are representing somebody, you are just a lawyer representing somebody, until you come to the LPDC and then you find out that you yourself, you become, respondents before the committee. So there are so many instances. The issue of cost, for example, is something that we are not and need to set up. If you want to file ahead of time, not on the date of hearing. So these are some of the examples of cases that we have. And then also the duty, one of the duty also is lawyers should look at what they file. I think the prof made that point in his presentation. It's not that a lawyer decides to, or a client decides to write up something and then you go ahead and just file. Also on the 21st of January this year, 2025, a lawyer representing an applicant was adopting his affidavit. And then he told the committee that there was an affidavit called liar 1 to liar 13. Liar as in to tell lies, liar 1 to liar 13. And the committee found that such use of language in an affidavit. And then the committee immediately struck out that case. Because it's wrong for you to use those kind of words. You can, for exhibits, you can name it anything. But of all the things you want to name an affidavit, you name it liar 1 to liar 13. So lawyers also, we have a role to play in ensuring that, we present facts before the committee in a just and proper manner. Thank you.
Thank you very much, Mr. Casson. I will say what Dr. Obiene had said before. I think we should, as lawyers, we should actually stay away from LPDC. Apart from that, I'm aware that the process to re-enlist, it's also a bit of cumbersome process. Do you really want to talk about it?
Okay, so for example, if you are suspended for 2 years and you decide not to appeal the decision of the LPDC, at the end of 2 years, you have to file a motion for reinstatement at the LPDC. And one of the requirements simply is, in the wisdom of the committee, it's like you are entering into the profession afresh. If you remember, for those who are young lawyers here, you have to be sponsored by 2 benchers before you can be called to the bar. So if you have been suspended and you want to come back, you still need letters of attestation from 2 senior lawyers, most times life benchers or benchers, to recommend you to be brought back to the profession. It is only after you do that that the committee will consider. And then one of the rules the NBA so is that that motion will be sent to the NBA for them to investigate. Okay, in these 2 years you've been suspended. Were you carrying out any job as a legal practitioner? Did you apply for your stamp and seal, for example? Do you pay a practicing fee? Those at your jurisdiction, did you appear in any court case? So, it's really the most important thing is just to try and avoid it. Thank you.
Thank you very much. Our learned Silk would like to ask a question or make a comment.
Thank you very much. I'm happy to see Katun there. I was a prosecutor for a few years, and I'm also counsel to the LPDC on a few matters. I wanted to just agree with you on the point about the quorum, particularly given the decisions in Kalaja A and LPDC and Genuba and LPDC, which says that the panel of 5, it must be the same set. I think that must be an issue affecting the composition and sitting. And despite that, the LPDC is sitting. So I would like Dr. Chinedu to also look at that as possibly a reason why maybe his own, I don't have the empirical evidence because it's been a while I've looked at it, but maybe it can be the issue of quorum that is affecting that. And I want to find out what LPDC is doing with regards to this issue of quorum. How are you solving the problem with regards to the issue of quorum, giving these decisions? And we can see a lot of decisions. If you go to the Supreme Court now, you are having very clear cases of misconduct struck out simply because of this technicality on the issue of quorum. What is the LPDC doing about this to ensure that we get to the root of the matter? Are matters being referred back after the Supreme Court has struck them out? Please, thank you.
Okay, sir. And you are going to do.
Yeah, thank you. The session has been quite illuminating. I do not agree that the bar must be named or be part of the proceedings of LPDC for it to work. No, I don't agree. On all the places where we are copying from, all of them, the bar does not play any role. Once it goes to a tribunal, as some of them use the word tribunal itself,
committee, LPDC. There's a machinery, the standard board and all that, they're all out of it, at that point. So but there are rules we can play as you have highlighted. The ethics committee, for example, set up by the bar, the limitation is that it is only to deal with complaints sent to it by the president. That's all that he has to do. Now, since the rule, the law constitution was amended, the first time it was set up was only last 2 years. Half of the time had gone, half of the session of the president had gone, half of the tenure had gone. So they only had a very short time to deal with them. Now, there was a problem which Dr. raised, which was the main problem why the ethics committee cannot do that optimal work as suggested by our guys. The LPDC still insists on doing primary first aid cases, even when MB has done one. So it becomes a waste of time. You wasting anybody's time. You go and do primary first aid case for many months, then you start all over again. So that's the anger of MBA, which has been reflected in Dr. Obiano's work. He's very angry about it, and that's a real anger of the MBA. He's talking for the MBA in that respect. Why are you wasting our time? So that's why MBA just hands off, totally. But my advice in dealing with those cases when I chaired the committee was that we had 100 and something cases, and 100 and something cases, up to 100. The clients have been told, the petitioner have been told to direct their petitions to the LPD. Since LPDs like cases, they like cases, take. So we couldn't redo those cases again because they had hands off. So we only did those. The MB office had not done anything about. That's what we dealt with. Now, that can be followed up if we get that kind of synergy you are raising, where we now agree, if we have a petition and the ethics committee look at it and give you a primary first aid case or not, you shouldn't go and redo the primary first aid case. You just have to continue. Whereas if you do that, the MBA will be wasting their time, so they won't like to do it. On the other hand, we say, look, since MBA can petition on its own, as you said, and that's the right thing to do, since it's a body, MBA can restrict itself only to the ones he wants to charge by himself. So those ones he wants to charge by himself, is like the last president complained against one lawyer who said something in IBA conference. That's an MBA petition. So such petitions are the ones now that we can now send to the ethics committee to investigate, since MBA wants to charge it themselves. So instead of doing correspondence of complaints from people to MBA, it's a waste of time. The MBA can activate its own machinery of this thing we're looking for, and somebody else being complained other than individuals, especially when it has to do with duties to the principal, not just due to the client. So MBA can generate those ones, and the ethics committee will deal with them and then send to. So we can still play a role. The only thing I can urge us is to lessen our anger, reduce our anger, so we can work together and see where we can meet halfway. I do not also agree that the rules of 2020, strictly speaking, gives the LPDs an investigatory power. The word investigation is there, but it's not really what they are playing. The role they are playing is primary first aid case. And if you look at our judicial system, a tribunal is the tribunal that will decide the primary first aid case. So there's no other law about it. If you go to court, High Court, and present a case, it's the High Court that will decide whether you have primary first aid case or not. Are you going to call a third person to come and decide it? So, as a common law principle, primary first aid decisions are made by the judicial body sitting over the matter. So there's nothing wrong with that. The only thing wrong, which you have pointed out and which you have agreed has a limitation, is the number and the time frame and the quality of the status of the membership. Most of them are by virtue of office, and they are doing other things. And so 11 cannot form a real quorum out of 5 because of their different work. So what we have done now is that the compromise LPA, which we have drafted now between the Attorney General, Board of Benchers, and the bar, now makes provision that the membership is not stated as per name. So what we have now is, let me just read it, just a paragraph. What we now have is good. The Spelling Committee shall consist. The Spelling Committee shall consist of a chairman who is not the Chief Justice of Nigeria or a Justice of the Supreme Court, and such additional number of members as the body of benchers may appoint for the effective conduct of the business of the Spelling Committee. So we left the number open, so we can appoint 100. This board of benchers can appoint 100 people in a year. And they can appoint, and they don't need to, we don't state qualifications and so on and who must come from. So the board of benchers will be, very elastic for them to make those decisions. So that will help. And because this was a compromise on the ad hoc proposal I had made, which was enacted, which was put in the 2004 Act, 2007 Act, 2012 Act, 2018 Act of APA, which didn't see the light of day, for the disciplinary committee to be an ad hoc committee. So that if you have a case, say in Calabar, you appoint the members of a disciplinary committee to deal with it as a terms of reference and it ends. That would have been very fast. But the compromise is that this committee now shall have more than one panel. So while the board of benchers can appoint as many numbers as they want, they are permitted to sit in panels at a time, and a panel is members to sit in divisions. So you don't need to be in Abuja alone. And we also made the very low 3, so that it will be easy to work with. So if we can generate some energy and get this bill passed, it may help us with the disciplinary process. I do not agree that it is a disciplinary problem for lawyers to sell house. I've never agreed. And we are not going to allow that in the new rules. Go to the website of our solicitors, even though they are distinguished between solicitors and barristers. The main business of solicitors in England is management of property. You don't manage property. If you die for hunger, so it has been for me, it has been a wrong trail of decision making. Which I found that in those decisions where the lawyers were disciplined, the real matter was the pushing of the money. But Nigerians like to hang in on something, but because of their side decisions on the compromise that created the wahala of money was this land or house selling, we are all dancing and saying, you can't sell land, you can't help. No. The main issues in those cases was the handling of the money. So we can rebuild that. And so one of the problems we created in our LP over years that our law does not provide the work of the law in Nigeria. Because they have a list of things lawyers can do, list of things they may do, list of things they cannot do. It's always in all the laws except Nigerian own. So here we have tried to put some lists too of what we can do and areas we can go halfway and others. And we are permitted to manage, negotiate responsibilities. So that responsibility, house no follow. House will follow responsibility. If you know one regular, you can house follow. I don't think so. You go wrong for people to say, the house supposed to be sold. Even though I didn't sell, I've never been lucky. I've never been lucky with solicitor work. So I stay away from it. But one other thing I must point out is that the issue about management of funds is so critical. You raise these guys, you said it's the main problem. Police don't know how to manage funds. First, if I do a statistics that say make you raise the hand, not many of us have client account for background. Client account is the thing. If you go to the disciplinary committee, it's not the petition. At least when David was there, it was an issue. And I loved it. It's not the petition of why you are disciplinary committee. Then I ask you, where is your client account? And I like they add that one to the charge immediately. That's the main one. You don't have a client account. There's no way you can be responsible for much money. There's no way. It's a simple account in the bank. You're not keeping it at home. It's a simple account, it's just for you to designate it, bracket, client's account. One only, you don't need to have two. Where you cannot take money, I give you instances, money is paid there, my client pays money, not, he pays money for costs of doing a matter. I cannot take money from there and give my lawyer 20,000, 50,000, unless my lawyer generates an expense invoice, and I will approve and then issue a check to my lawyer. Then when my lawyer finishes, he now does an account and reports back, which we will file to the client, showing all the receipts. And when the receipt is not receivable, no correct say you give money to clerk, because that's a crime. You can sign what we call good faith statement. This was all received on my honor certificate. On my honor, this was sent without receipt. Like some transport will do, not necessarily by now that will give receipt. So that's everything, and so forward to the client. And if your own fee has been paid there, which is wrong, because you want your client to pay your fee, this is important to pay to your own firm account for your fee. Separate your fee from his expense. To one voice for deposit of cost, and get his consent to deposit an account to it. Simple thing. So if we continue chopping clients' money, but we continue buying us from selling property, we could have stopped, not with the sell property.
Thank you very much, sir. Thank you very much, the Daniel Silk. We have now come to the end of this session. I would like you to give 2 seconds closing remark, both of you, because we need to go into another session immediately. Thank you very much. Thank you for your time and thank you for listening.
Okay. My closing remarks simply will be to encourage our colleagues to the sitting of the LPDC is open to the general public. When you have time, please just stop by and view the proceedings. You will learn a lot. Thank you.
So one recommendation for you guys that we are not seeing those cases. That's the major problem. Maybe can come in there, Doc. Let's have their reports on our website. Nobody should print it for sale. You don't edit if you don't want. Let's have the reports the one decided on the website, because when we don't have the information, we don't know anything is going on.
Okay, just to respond to that, the issue with that simply is most of the time, if is found liable, he files an appeal immediately, and based on that, we can't do anything about it.
Don't send it home, but that report you can still go to the law report. If you want to edit it, or editor will write filed an appeal on Sunday. All the cases, the only law report we have with our brother, and all of them are very important, and they will be wait for appeals to finish for those cases to be reported in the Board of Ventures disciplinary law report. When there's an appeal, the next edition, you add the appeal on. But if you want to put it on the website, it's a very simple thing. You filed an appeal. But we need the decision to be publicized. Filed an appeal on the footnote of the website.
Thank you very much, Daniel Silk.
Okay, my final word will be, as a lawyer, make sure you stay away from LPDC. Then, if for any reason you find yourself in LPDC, respond to every line of allegation against you. Respond to every line of allegation against you, paragraph by paragraph. Then if you want to test your own integrity, I want to say that all these committee of friends will do, and your friends trust you to use your accounts to collect money for committee of friends. Thank you.
Let me respond to the question of Mr. Paul Daudu, SAN. You raised a question about the quorum of the LPDC. Yeah, so since the decision of the LPDC in Obiajulu Walutu in 2019, and then the coming of the rules in 2020, the LPDC is strict about quorum. So we now sit in panels. Currently, we have 3 panels, and they sit 5 members each. And the 5 that start will be the 5 that will finish. If there is no quorum, the committee will rather adjourn and not hear cases at all. Thank you.
Thank you very much, everybody, for listening. We're going into another session right now. Thank you, Mr. Carson, for your time. Thank you, Dr. Obiano, for your time as well. And thank you for listening. Thank you very much. We're going into another session now. Okay, they said we have to. They said.
Cody.
That's, it's advocates of Nigeria here present. That's Vice President of the NBA. Please join them for pictures. These all national officers, please come to the stage. Very quickly, we are going to go to the next session. Dr. Chinedu Fovieni, you are still there. You can wait, please. We are going to have maybe I'll call it a joint session. But before then, I see 2 more hosts here. Where is Garakiche? Please, Anthony Bamidele Ojo, the chairman of MBA Garaki branch. Please, a round of applause for our co-chair. Then the elephant in the room, Paul Daudu, SAN, the chairman of Wari branch. Need a round of applause for him. Now, very quickly before we go to the next session, which will be a joint one, there are some of us that I feel we all make sacrifices to be here. When the MD president was speaking earlier, he talked about people coming from as far as Jalingo, people coming, traveling long distances by road just to be part of this. It's not as if we don't have what we are doing. But you see, the thing is that for some of us, the MBA is a way of life. When they call, we come. Yes, very quickly, I want to, Mr. Eddie Ofe, is he here? Ofe, the chairman of Econ branch. Is he here? Please, where is he? Please, can we all look at that man?
He came all the way from Ecom. I don't know whether we know where Ecom is. Ecom is at the end of, it's in River State. That man is about 60 years. His flight was cancelled and he got on the road and he got into Abuja today around 6 a.m. It's a round of applause for this is the spirit of the MBA. He got to the hotel, took his bath, and he came here. That is why we do what we do. And this is why am I saying this? For those of us who are young lawyers here, that is why people like that lead. Because they will commit their time, their resources, their energy to make the MBA what it is to do and seek to make it better. Yesterday, Mr. Kimsi Olufemero, the chairman of Oji River, is he here? Mr. Where is he? Please stand up. Yesterday was his birthday. Can we all stand up and give him a rousing applause? Please, he has earned it. Yesterday was his birthday. He came here to be with us. Happy birthday. Thank you, Mr. Chairman. So very quickly, we're going to have a joint session. We're going to be discussing the lawyer-client relationship and ethical duties. That will be taken by Mr. Oluwatosin Olufon. Please come to the stage. We're also going to discuss duties to the court. It's a round of applause for our speaker. We're also going to discuss duties to the courts and ethical advocacy. That will be taken by Mohammed Adelodun. Please, he can come to the stage. Is Mr. Mohammed Adelodun here? Please, a round of applause for him. Now, the last but not the least, duties to fellow lawyers and the legal profession, Dr. Chinedu Obienu. Okay, Dr. Chinedu will join us as soon as he comes. Is Mr. Harry Barnabas here? Our Assistant General Secretary.
Doing this once more. Okay.
So very quickly, we'll get into this session. Dr. Chinedu will join us immediately. He comes back into the room. Please, a round of applause once more for our panelists. Thank you very much.
Good afternoon, everybody. I welcome everybody once again. I stand on the existing protocol. I know that some of us will be wondering if we've been summoned here to listen to how we will be disciplined and punished as lawyers for offending the provisions of the rules of professional conduct. And that kind of conversation might have tensed the atmosphere. But before I proceed, I would like to know if there's any foreigner in this room. Is there any non-Nigerian in this room? Okay, if there's no non-Nigerian in this room, we'll have this conversation like real Nigerians in the practice of law. My presentation is supposed to deal with part 2 of the RPC, which covers rules 14 down to 25. I think that we already know what the rules says. And I would like us to proceed with this conversation by paying attention to the need for us to achieve a universal acceptability for the provisions of the rules with the consciousness that the entirety of the requirements set out is designed to guarantee our success as lawyers. So I would like to set a title for the presentation, which will be a regulation imposed or a regulation to embrace. The RPC as it is, particularly Part 2, Sections 15, Rules 15 to 25. Are they regulations imposed on us, or are they regulations to embrace? The provisions of these regulations in this part governs our dealings with our clients. For lawyers, there is no making money for us if we do not have interactions with clients, because that is the stock of our trade. And essentially, there are several pitfalls in dealing with clients, which some of us have navigated successfully, some people not so successfully. Now, a couple of questions will come to mind when we talk about our lawyer-client relationships. A couple of questions will come to mind. As lawyers, the only thing we do is legal practice. The only thing we're expected to make money from is legal practice. And in the spirit of dealing with this, as real Nigerians, you know, having the real Nigerian challenge and being in legal practice, a question comes to mind, and I know you have several questions of yours too. The question that a 26-year-old who is 4 years post-call, has no wife, has no children, has no direct dependent, compared to a 43-year-old or a 46-year-old who is also 6 years post-call, has a wife, has 4 kids, has no property of his own, is probably renting a residential premises, probably renting an office. Will these two lawyers, even though they are call mates, will their disposition to adhering to the rules be the same? You know, these are one of the things that we need to put into considerations as lawyers in dealing with adherence to the rules, because the essence of this event is essentially to get us to a place of adhering to the rules, you know, in a better way, adhering to the rules, achieving enhanced adherence to the rules of professional conduct. Some young lawyers will ask, what are the chances of having a decent, lucrative legal practice if I adhere strictly to the rules? You consider the provisions of Rule 16 of the RPC. Consider the provisions of Rule 22 of the RPC, the provisions of Rule 23 of the RPC. How many lawyers seated here have never gone to their client's house or place of business? Is there any lawyer here who can raise his hand? So I'm not trying to indict anybody. Can we have some participation, please? Is there anybody here who has never had cause to go to his client's house or place of business? Honestly, in-house. Because definitely there are clients that will not patronize you if you do not go to their house. In fact, there are clients that will not come to your office. How do you navigate adherence to those kind of rules? And how do you survive? Especially in a profession where we actually do not make money every day, except lawyers who want to break down their retainer fees into hourly earnings or daily earnings. We actually do not make money every day. We are in a practice where we have to exercise a lot of discipline, a lot of restraint, you know, and a lot of standby, a lot of staying power. Another question that comes to mind is it possible to attain a successful career by strict adherence to the rules, a young lawyer will think, is there any lawyer who has actually succeeded in the practice of law by adhering strictly to these rules? These questions and many more that might come from the audience will form the basis of our conversation as we go on in this part of the session. Recently, I came across a case that was decided by the LPDC where a lawyer took the brief of a client somewhere in Kuje Area Council in Abuja. He took the brief of his client to file a petition for dissolution of marriage. From the facts of the case, the client negotiated the fee, the lawyer's fee, from about 120,000 naira to 50,000 naira. The lawyer had to take the case, and maybe at the time he took the case, he really needed some money to get some things done. The lawyer prepared the processes. He initially tried to settle the man and his wife, and he didn't make any progress, and that took about a couple of months. He finally filed the papers. The client reported him to the police that he didn't perform his obligation as a lawyer. He didn't deliver on the brief that he took. The police invited the lawyer, and the lawyer answered the police, wrote a statement. Eventually, the matter went to the LPDC. It was discovered at the LPDC that the lawyer actually filed the case. The matter came up a couple of times, and the judge who was presiding over the matter passed on. And so there was no way to conclude the matter because the judge was not reassigned to the court immediately. The LPDC dismissed the petition on the basis that the reporting of the matter to the police was a show to a display by the client to his lawyer that he didn't have confidence in him. And it was at that time that the lawyer should have acquitted himself of the brief. So in dealing with clients, how do we handle issues? How do we handle issues where the client does not show confidence? The client doesn't show confidence at times, even when it comes to agreeing to pay fees. When a client doesn't agree to pay your legal fees, it's a sign of not showing confidence in the service that you're going to offer. So most of the time, when lawyers suffer these kind of consequences as a result of the lack of confidence on the part of the client, they actually saw it coming, have an issue. It didn't just happen, But at times, in order to make ends meet, lawyers take this brief and try to manage them and go along with the client. Sometimes it turns out well, sometimes it doesn't turn out well. This will be my opening presentation in respect of next session. Thank you very much.
Good afternoon, everybody. Learned Senior Advocate of Nigeria. Senior. Simply because many of the people present here are quite experienced and quite adept with the rules of professional conduct. And so what we're doing here is not different from what we do when we go to churches and mosques. We all have the scripture, we know what the scripture says, but we still go on Sundays, and for Muslims, we go as often as possible to be reminded of what you already know. the rules of professional conduct are, albeit we have a new rules. What we're trying to do is to socialize the issues that are play as far as the rules of professional conduct are concerned. The slide, I don't know if you have a slide, please. So, this is now a combined session. I'll just roll through the slides, and hopefully we can have an interactive session as we proceed in the day. So, to speak about chapter 4 of the rules of professional conduct, and particularly rules 30 to 38, which are the duties of counsel to the courts. When we talk about the duty of counsel to the court, we'll talk about the duty of counsel to his clients, because we're not in courts for our own sakes, we're there representing clients. So in discharging our duties to the clients, we must be reminded and we must have at the back of our minds that firstly, we're called to the bar. And our duty, our primary duty at all times, is to the courts. So we're not simply trying to win cases at all costs. We're trying to advance the cause of justice. Now, straightforward as that sounds, we find, as we often would have found, that these duties seem to conflict in many peculiar circumstances, and that is that's the world of practice. So, presentation is the role of the lawyer, duties to the courts, and ethical advocacy. This introduction, I'll skip it. It's essentially what I've done. To be reminded that our profession is founded on the principles of integrity, honesty, and rule of law. Now, just so that I'm not speaking just to my own opinion about what it is, Justice Nikki Tumi, and it says, I would like to say that in the judicial process, both counsel and the courts are joint partners in the search of justice, the bedrock of any legal system built on the tenets of democracy and the rule of law. It is the interest of justice that we all adhere and pursue, that neither counsel nor the courts, on the courts, outsmart or discredit one another. And this is more so when neither can exist without the other. And that is why they are joint partners in progress, not in the sense of corporate entity. It is possible I am wrong. And that is humility on the part of his lordship. A counsel who tries to ridicule the courts ridicules himself, because he, like the court, is an articulate and indispensable part of administration of justice. Again, our role in the passion of the moment is, as part of the judicial architecture, is to advance the cause of justice. And if we have this in mind, conflicted as things may seem, find that we can always maintain a fine balance. So some of these rules are pretty straightforward, but some, as we talk about, sound easy, but you find that the practice of it is tricky. One is to treat the court with respect, dignity, and honor. That is straightforward. To conduct themselves candidly and fairly in all dealings. To disclose advanced legal authorities and factual information. This is one of the ones that I think is a little tricky. And just so we understand how tricky that can be, if we can have an indication by show of hand, has anybody here furnished the courts to an authority contrary to their position in a matter? Has anybody ever done it, please? Any show of hand, please. No, sir. You have. Very much. Secondly, you are one, sir. Persons that have furnished the court. They have furnished the court with adverse authority. And how did he go in that case? You have. You still won. Authority. It's interesting. And maybe in the course of this conversation, we'll socialize that. But it is safe to assume that as lawyer, you're mostly occupied with authorities that are in support of your position and not so much of what is against you. But this is our duty, and the duty to do this, as we can see. I will socialize this more in the course of our discussion. To refrain from making extrajudicial statements that could prejudice a trial or interfere with the fair administration of justice. This is straightforward. To maintain a professional relationship with judges and avoid seeking special considerations or favors. Straightforward. To comply with established rules of procedure, customs, courts, and tribunal traditions, and avoid undignified or discourteous conduct in all professional interactions. What I think is interesting, which I would underline, is local customs. How this varies from place to place is quite interesting, and it's interesting that we have this in our rules to defend their clients zealously while ensuring justice is served. This is straightforward. Once assigned to defend indigent accused, must provide diligent and competent representation, requesting to be excused only for substantial reasons. This is quite straightforward. Consequences of this established quite straightforward. You easily be in contempt of courts. Consequences there too. You could find yourself defending disciplinary actions, loss of privileges, damage to reputation, and sanction by the courts. Now, these are things that, to that is not highlighted here. And what we have at the back of our minds is that as lawyers, we represent the profession wherever we go, whatever we do. So outside of our professional duties, everything we do reflects on how the public perceives the profession. There was the unfortunate case of, I don't know if it was a chairman or an ex-school, a branch ex-school member, battered his wife. Now, he didn't do it as a lawyer, but what you find, the trend it generated is, lawyer batters his wife, lawyer inflicts injury on his wife. And those are some of the consequences that we may not see. That is not written on the rules of professional conduct, but it is part and parcel of the rules of professional conduct supposed to safeguard the perception of the profession to the larger society. Now, that's as far as the strict rules are concerned. Ethical advocacy is the cornerstone of the profession. It is not just an imperative, but a professional obligation that underpins the very fabric of our legal system. I also found the decision of NDU versus Lawal, which is in presentation. The practitioner, whether acting by office or not, is in the eyes of society, not only between bystander can leave his valuable and proceed on a journey and return to meet his property intact. Such was how the legal practitioner was highly revered in those days. Thus, a lawyer possesses enviable duty to be civil, honest, and decorous at all times. Now, the challenge to all of us in this room and outside of it is, why is it that such was how the legal practitioner was highly revered in those days? Why are the days of our positive perception, why does it seem to be behind us? Now, Leonard Silk and our seniors will have more to say about that. But also, they passed some of the consequence of this. And it is for us, the younger ones, to make sure that that perception, because in that perception, it's our ability to come to us as legal practitioners, for people to look up to us, and for us to continue to have a profession to call our own. I want to, okay, so for 32, it says disclose adverse legal authorities and all that, but there are some paragraphs that are not, that we need to talk about, including refrain from asking irrelevant questions. That seems mundane, but happens in courtrooms. Avoid asserting personal knowledge or opinions except where testifying as witness. Comply with local customs and practice of the bar. Avoid violating established procedure. Refrain from disputing content of the paper, testimony of witness, citing invalid authorities. Avoid asserting unproven facts, misleading evidence. Refrain from producing evidence that should be rejected and promote a false case. Avoid abusing court process or engage in dishonorable conduct. Abuse of court process, the very many ways that manifests itself. That even the courts struggle to define as abuse of, is the concept of abuse of court process, because of the very many ways among us that they present themselves. And really, it is us that abuse the process of court. A client would ask all they want. It is for us to be able to say, in the ambit of the law, to X, Y, Z. For as long as we try and go out of our way to satisfy what clients want, and clients are like patients. People go to hospital, they just want to be well. Clients come to lawyers, they just want to win. It is for lawyers to tailor their cases in the ambit of what the law allows. This continues to happen. And we have lawyers advocacy ones. It's ethical advocacy, and confidentiality. Now, for liberty and confidentiality, which principles cultivate the trust essential to a client relationship, professional competence, and just to go to, I mean, what I say about professional conduct, same thing with infamous conduct. It's not, you can't tie it to just the things that are on the letters of our rules. It's further than that. And I found this definition: any conduct that constitutes an infraction, I believe, as of an acceptable standard of behavior or ethics of the legal profession, or any conduct which connotes conduct despicable and morally reprehensible to bring the legal profession into disrepute, condoned or punished, will amount to misconduct. Now, that is wide. And that is where we all have to understand that it's not just in the letters of our rules, but in the spirit of it. And the spirit is to show integrity in all that we do. Examples of infamous conduct, we see it all the time: perversion of justice, fraud, theft, misappropriation, bribery, breach of confidentiality. Consequences, as enumerated earlier: loss of license, prosecution, disciplinary measures, loss of clientele, legal liability. And this takes us to my conclusion. Now, that's word for word. It goes back to what I'm saying, that whether how the society perceives us as lawyers, what becomes of our profession is based on our choices. Enjoy a profession that would enjoy the respect of the society, it is for us to ingrain it in ourselves, ingrain it in our firms, and make sure in everything we do, justice is centered at our hearts and in our conduct. Thank you very much.
For our last speakers. Are we that tired? Please, let's give our brother a round of applause. He did justice to that. So quickly, Dr. Chinedu Obdenu is going to do justice to duties to fellow lawyers and the legal profession. We're also calling the Assistant General Secretary, Henry Barnabas, is going to be speaking. It's an interactive section anyway, enhancing the image of the legal profession. We're going to talk about our individual roles in maintaining public perception, and then we'll do a recap of what the last three speakers before him has done. Thank you very much. Okay, it's afternoon now. Good afternoon, gentlemen. At the last session when I was speaking, I was speaking for us against LPDC. Now it's time to tell ourselves the truth. I want to start from the end. Every conduct of a lawyer, whether the big one or the small one, the one done in public, the one done in secret, once it is out, is subject to the same class of sanctions. Is subject to the same class of sanctions. And as I said earlier, the greatest problem and challenge with those sanctions is that they are discretionary. My PowerPoint. Okay, my PowerPoint. Okay. Now, whether it is whether it falls into the big category of fraud or not, whether it is sale of property, whether it is an agency issue, whether it is refund of money, no matter how small it is, it's subject to the same classes of sanctions. Now, this afternoon, I'll be speaking on duties to fellow lawyers and the legal profession. Note that any infraction on the duties you owe me is as big as the infraction to the duties you owe the courts. None is higher than the other one. There are so many things we do as lawyers that we just need to be reminded that there are duties we owe one another. So at the end of this paper, it is my hope that we will appreciate the essential duties we owe each other, understand that these duties, as they are called, are mandatory. They are things that you must do. They are laws, even though they come in the mode of duties. It is not something that is discretional. They are compulsory. Then I've treated the last one, but there are sanctions to it. What are these duties? I'm of the view
I'm of the view is that these duties, which you can find in 26, the first one is to treat each other with respect. Courtesy. Very simple rule. But the punishment for it can lead to suspension. Fairness, consideration, and with dignity. But they sound subjective. For instance, what I consider that should be the way I should be treated is not the way you consider. It may be subjective. It is a rule. It is a rule. I don't like to shake hands because maybe my religion does not permit it. Then you come and hug me. I don't know whether we are on the same page. Dignity, fairness. I don't even shake hands, but you decided to hug me. We need to be careful when dealing with the rules we owe each other. Then, for those of us that practice, we have this attitude of fighting for our clients. May I announce to you this afternoon that you're not a litigant. You have no business fighting me on the other side as a lawyer doing my work because of your client. A senior lawyer once poked his hand on my face for bringing an application in the court. I left him with my client. They fought in court. In the city high court here, not somewhere far away. Now, why will I bring that application? I'm wondering whether the senior lawyer is the client. I just barely did my job. I want to say that it is a misconduct for you to become a client fighting the lawyer on the other side. If I had known that, I may have written a petition against him. Then I'll take the last two together. Respect for seniority and equality of status. Status, we are all lawyers. We are what? All lawyers. I need to respect the fact that you're a lawyer. I once stood up in courts because he's my senior to sit down. He had finished making an application. The court said I should respond. He kept shouting I should sit down. I got up and said, sir, I came all the way from Abuja. I didn't come to Maiduguri to sit down. He shouted and that the court is not protecting him. The panel, for the election petition, the panel said, you have been shouting at him since. You didn't come all the way from Abuja to sit down. That was the end of the matter. He didn't appear for the next 2 weeks because he felt bad. But the panel protected me because I didn't. So as long as we are lawyers, there's a basis for you to give me a respect as a lawyer. Then there is a basis for me to respect you as a senior. Can I say that these simple things can lead to LPDC? And you can lose your certificates for these simple things. Let's go to the next rule. Rule 27. Good faith and fairness. Everybody that go to court here, almost everybody that go to court here has witnessed the first one. It is now difficult for lawyers to obey promises made to opposing counsel. The rule said that you must obey all Observe all promises you have made. Why don't you tell the lawyer that I will not agree to adjournment? Why agree to adjournment? He says a junior to court, you say the matter is for hearing. That this is definite hearing that we must continue. It is misconduct. In fact, you said whether oral or written, even the conduct. Once you have made a promise to the opposing counsel, you owe him the duty to make sure that that promise is fulfilled. I will go back to my opening remark. The beauty of a legal practitioner is his ability to conduct himself in a manner that his colleagues and members of the public can say that he or she is a person of integrity. Can your word stand? Can your word stand? Can I tell you, I'll meet you by 6. And if by 6 I'm not there, I should be able to call you and say, please, something is happening.